Hmm. It's okay.
And
They got
nobody
on.
has information.
They got on.
Okay, so, okay.
We're gonna start in 1 minute. Sorry, I could troubleshoot on break, but.
Good morning, everyone. Now calling proceeding number 23AL-0231G. This is an evidentiary hearing on Black Hills Colorado Gas Inc.'s advice letter number 32 to increase base rates for all natural gas sales and transportation services. This hearing was scheduled by decision number R23-0532-I. Today is November 29th and it is 9:00 a.m. My name is Melody Mirbaba and I am the administrative law judge who was assigned to hear this case. Consistent with commission practice, we are webcasting this proceeding. That includes both video and audio. We will continue to webcast this proceeding during any breaks that we take, so please do keep that in mind. The conversations you have in this courtroom will be broadcast on YouTube. We also have a court reporter taking down everything that's being said here today, so please be mindful of that as you speak. Hopefully I will remember to remind all the witnesses to try to speak as slowly and clearly as possible. Let's get started with entries of appearance. I want to start with Black Hills.
Good morning, Your Honor. Emmanuel Koshin, Associate General Counsel for Black Hills Colorado Gas, and also with me is co-counsel Mr. Albright with the law offices, James D. Albright.
Good morning. For the Office of the Utility Consumer Advocate, who I will refer to as the UCA.
Good morning, Your Honor. Michelle Singer Nelson, Assistant Attorney General, appearing on behalf of the UCA, and with me as co-counsel is Greg Bunker. He's here virtually, and he's Senior Assistant Attorney General, also representing the UCA.
We just lost audio, Your Honor.
I'm aware there's a problem with the Zoom. Don't worry, I'm gonna get it back and running. You don't all need to email me telling me. I see it.
Welcome back, Mark. Hey, I don't know if you got cut off or if you heard Casey Frederico indicate that she sees the problem with the Zoom call and she's taking care of it.
I can hear you. I can hear you now. I don't know if I can hear the hearing room.
No, I can't either.
Okay, good.
But Casey indicated she was taking care of, she saw the problem, was taking care of it. And you seemed to drop off the call just about that time when she said that.
Yeah. Thanks, Greg.
Yeah, not a problem.
Testing 1, 2, 3.
I can hear you now, Ms. Federico.
Give me 1 second. Thank you. Okay, good. That's on. You have to delete yours.
Okay, can everybody hear us, who have joined us remotely? All right,
Yes.
thank God. All right, we'll go back on the record. Okay, so can we get an entry of appearance for the Colorado Public Utilities Commission trial staff?
Good morning, Your Honor. Kevin Opp, Special Assistant Attorney General, appearing on behalf of staff.
Thank you. And for Walmart Inc.
Morning, Your Honor. Julie Clark of Clark Flegge on behalf of Walmart.
Okay, and for AM Gas Transfer Corp., who I will refer to as AM Gas.
Good morning, Your Honor. Mark Valentine from the law firm of Keys and Fox on behalf of AM Gas.
Okay. Thank you. All right, I've got a list of preliminary matters I'd like to discuss before we get started on the administrative portion of this hearing, and then I will certainly allow anybody, if you all have preliminary matters to raise, I will provide that opportunity. So just first, as a general matter, we will be taking 2 15-minute breaks today, one mid-morning around 10:30, and then another sometime around 3 o'clock in the afternoon. We will take a lunch break right around noon for an hour. I'll just let you all know that as of right now, I have questions for the company's witnesses, and most definitely for AM Gas's witness, and possibly for staff and the UCA's witnesses. I do not have any questions for Walmart's witnesses. And as much as I'd like to tell you exactly which of your witnesses I will have questions for, it's hard for me to determine who will have the answer. So my plan is to ask the question of whoever is put on first, and if they can answer it, great. If not, then that means we need another witness. So that's how we'll sort through that. I'm just anticipating you all wanting the ability to excuse witnesses. I can't necessarily do that at this time. I also just want to put everybody on notice, particularly those who have signed on to the settlement agreement in this case, that many of the questions, or at least some of the questions that I will be asking, may essentially result in a clarification or even modification of the settlement agreement language. And I'm going to expect that if a settling party disagrees with any clarification or modification that is made during testimony, that you will ensure that is made clear in the record in however which way you would like. I want to talk next about exhibits. We're going to do our best to get exhibits admitted for the most part using administrative notice, which essentially means we've got this spreadsheet that was circulated to all the parties prior to the hearing, listing all the exhibits that the parties would be offering into evidence. Parties were supposed to review that exhibit list to ensure that it is accurate. Exhibits were not included on that exhibit list that are problematic, exhibits that were marked incorrectly or have major issues. And that will be the next topic that I will get into after we get through the exhibits on the exhibit list. So what I would like to do is ask the parties if there is a agreement or stipulation as to the admission of the exhibits that are included on the exhibit list.
Yes, Your Honor, the parties did confer and would stipulate to the admission of all exhibits, including hearing exhibit 800.
Right, and just for the record, hearing exhibit 800 is the exhibit list. I do want to admit that. I'm going to do that at the end of the hearing in case it needs to be modified in some way, though I don't know that that's going to happen. All right, so then I will go ahead and admit all the exhibits listed on the exhibit list, which itself is hearing exhibit 800. This is a lot of exhibits, so I really don't want to go through and read each individual one. I think we can rely on hearing exhibit 800, which does list each exhibit that I have admitted. All right, so now turning to the issue that I alluded to a moment ago, and that is that we've got some significant and voluminous problems with how staff exhibits were marked and titled and filed in the case. My legal assistant reached out to staff, I think around November 9th, asking that these issues be corrected via refiling. And possibly some were, but it seems that in that process, more issues have come up, more problems. And as a result, a lot of staff's exhibits are not included on that spreadsheet. Staff was then asked to fix the errors again and load them into their box.com folder. In preparation for the hearing today, my legal assistant and myself looked at the exhibits in staff's box.com folder because we wanted to know whether the errors were fixed and whether they could be easily admitted today. And unfortunately, we're not in that position. At this point, there appears to be somewhere potentially in the range of 60 exhibits or attachments there too, with some error or problem that are in staff's box folder. But some of those exhibits in staff's box folder are on the spreadsheet and therefore may not require correction because we have just admitted them through the discussion we just had a moment ago. There are, however, at least 25 of staff's pre-filed exhibits or attachments that are in the box folder that have not been corrected and that are not included on the exhibit spreadsheet. And they have to be fixed. The problem that we have with these exhibits is that the manner in which they identify they're identified, either via electronic titling and how they're physically marked, has so many errors, so many mistakes, that I would have a difficulty even being able to identify what is being admitted into evidence and looking at those documents. So the errors, they absolutely just need to be fixed if these exhibits are going to come into evidence. So I want to make a record of the types of issues that we're dealing with. What I cannot do, what I will not do, is go through each individual exhibit and waste everybody's time and resources discussing each error and issue. Staff should have been able to correct this and should be able to correct this before we conclude our hearing. I'm going to give you about 4 or 5 highlights of the issues that we're dealing with so that you all can have a much better understanding why I see this as such a big problem for our case and our record. So for example, electronic titles, which is essentially the name used to save the document and file the document electronically, often do not match the actual exhibit or attachment number that is physically marked on the document itself. And that is contrary to paragraphs 14 and 15 of attachment B to decision number R23-0532I. And since all this evidence is, in this case, is electronic, the electronic title is important. It is what will show in the commission's electronic record as the exhibit that's been admitted into evidence. If that electronic title does not match what is actually on the document itself, there will be confusion in the record as to what is actually being admitted. It also means that one would have to open each individual exhibit to figure out exactly what it is and what the exhibit number is. And when there is an inconsistency in the electronic title and what is marked on the exhibit, I certainly am not in a position to make the judgment call as to what's correct. That is something staff has to figure out. Second theme I found is that we've got electronic titles that violate the naming conventions that were required by attachment B to decision number R23-0532I. So for example, the electronic titles, particularly on staff's attachments, do not include the full title of the document. It should say a hearing exhibit number, an attachment number, the witness's initials, and then the actual number of the attachment. All the attachments drop the hearing exhibit number. So we have to all guess as to what that is an attachment to. Second, failure is they don't identify correctly, that they don't file all executable exhibits. They don't identify all executable exhibits as executable. In updated versions of exhibits, staff failed to follow the naming conventions that require them to attach a rev and then a number. So it's clear what number revision the filing is. They didn't do that for a single amended exhibit. And then there's the issue of marking and identifying confidential and highly confidential exhibits. That was also not done correctly in many regards. Third, there were numerous errors in electronically titling and marking exhibits or attachments that could include confidential or highly confidential information. And these are the type of errors that could frankly result in confidential or highly confidential information being publicly disclosed. So if I were to admit them as is because they aren't marked correctly, they would be filed publicly. There's a good number of those that we've got as well. Other problems with some of the confidential or highly confidential exhibits is we've got some that have an electronic title that indicating the exhibit is confidential, but the exhibit itself is not physically marked as confidential. Or we've got, exhibits that are both physically marked as confidential and as public at the same time, which makes it confusing. And frankly, I don't know what is intended when it's indicated to be confidential and public at the same time. This brings up another issue that I don't think we need to resolve today, but I feel the need to formally, on the record, make sure everybody is aware that these are issues that exist both in the staff's documents that are in box, but also in many of staff's pre-filed exhibits. And the result is that it is pretty likely, almost certain, that some of staff's pre-filed exhibits may have publicly disclosed confidential or highly confidential information. My legal assistant did flag this issue, both to staff and I think all parties were included. And I will say, as of now, I haven't seen anything being corrected in the record. I'll just give you an example or two. Hearing exhibit 600, attachment FDS 8, which was filed on October 3rd, 2023. It was not filed as confidential. It was not identified as confidential. However, I can tell you that on November 20th, there was a hearing exhibit 600 FDS 8HC filed, meaning highly confidential. That was filed as highly confidential. However, the identical document was filed on October 3rd publicly. Everything in FDS H3 is public, and nobody has corrected that. Nobody has taken any action to fix that. And there are more than one exhibit where this is an issue. Hearing exhibit 600 FDS 16 filed on October 3rd as public is identical to hearing exhibit 600 FDS 16 HC filed as highly confidential on November 20th. I am just giving you a very small sampling of the issues. This is something everybody should be concerned about, especially if it's your confidential information being publicly disclosed. And frankly, counsel for staff has a professional obligation when you've been made aware that you've disclosed confidential information inadvertently to attempt to fix that problem and ask for anybody who has obtained those records to return them. So I'm frankly surprised this has not been addressed at this point. Another overarching theme of problems is that even where there is, we've got, you know, a confidential or highly confidential exhibit that may have been marked correctly and filed correctly, we don't necessarily have all public copies and public versions. A public version of a confidential or highly confidential exhibit should not say that it's public. That is not part of the naming convention. It should just be marked as it would ordinarily be marked, and then it would be redacted and include a notice of confidentiality on the document, that it includes public information. Not even that was done correctly either. Another concerning issue is that many of staff's confidential or highly confidential exhibits do not clearly identify the information that is claimed to be confidential or highly confidential. So without that kind of information, those exhibits fail to comply with Rule 1101A2 of the Commission's Rules of Practice and Procedure, which requires that each page of a document containing confidential or highly confidential information be clearly marked so that it is clear the information on each specific page, which information is confidential or highly confidential. Most parties meet this requirement by highlighting in different colors the information that is claimed to be confidential or highly confidential on each page in which such information appears, and including a key on the front page of the document identifying where such information exists. This was not done for all of staff's confidential or highly confidential exhibits, and therefore I will say it puts me and the rest of the parties and the commission and advisors at a disadvantage, as we will be unable to determine which information is public and which information is not. There are also other situations relating to documents that are in staff's box folder that don't even include any sort of hearing exhibit number, either electronically or on the document itself. And so if staff wants those exhibits to be admitted, those will also need to be corrected. I'll point you to documents in staff's box folder identified as confidential attach CPUC-1, and then there are other numbers that follow that. There are a whole bunch of those. Those are not assigned an exhibit number. That's not electronically titled as an exhibit number. It may not be marked with an exhibit number. Now, those are the themes. I'm going to give you a couple more specific examples as well. Hearing exhibit 601 attach NTG-6 in staff's box folder. I'm going to ask staff to open, I don't want this put on the screen, you'll understand in a minute why, but I'm going to ask staff to go ahead and open this document from your box folder. It's the only executable document in the folder with that name. So generally the theme for everything in staff's folder is it does not include the correct title, meaning the hearing exhibit number to which the attachment is attached to. That's the same for this document. The title doesn't say that it's executable. The electronic title of this document does not match the exhibit and attachment number physically marked on the document itself. In fact, the document is physically marked as hearing exhibit 601 attachment NTG 6C, but its electronic title does not include C, which indicates it's public and not confidential, which would mean that if I were to take it as marked, it would get filed as a public document. And then even looking at the document itself, there's nothing in it that would indicate what information is confidential and why it's confidential. Now I want to ask staff to open it from their box folder an exhibit titled electronically attachment NTG 6C, Rev. Not Rev 1, just Rev. Again, it's electronically, the title is incorrect. But based on its title, it should be the confidential PDF version of the executable exhibit that I just mentioned, but it is not even the same document. It's a completely different document than attachment NTG-6. So 6C, Rev, not the same document. And then now we've got an allegedly third version of the same attachment NTG-6C. This one has an additional public redacted Rev. So by calling it 6C, you're saying it's confidential, and then you're also then calling it public in the electronic title. Again, confusion about whether it's a confidential or a public document. It should not have a C or an HC if it is a public document. So therefore, it's again titled incorrectly. And if we were relying on this title, I wouldn't even know how it could be filed because it's internally inconsistent. Also, this is not the same document as attachment NTG-6. It may be the same document as the one I just reviewed, which was NTG-6C Rev. And then the attachment itself is also internally inconsistent in how it's marked. It's simultaneously physically marked both as Hearing Exhibit 601, attachment NTG-6C, and also Hearing Exhibit 604, attachment NTG-6C. Fourth, it's also, again, like I said, not the same document as the other one marked with the same exhibit number. Now, I'm going to look at one more attachment. And this is to Hearing Exhibit 601, attachment NTG-7. And we have one of these on the spreadsheet that I think has been admitted. But we also have several in staff's folder. And there is, I don't know if this is a confidential document based on what we're seeing in box. And so I want to highlight some of the problems with it. Looking at the one in staff's box folder, NTG-7C, public redacted Rev. Staff will look at that. That's how it's titled. 7C, public redacted Rev. So internally inconsistent in how it's even titled. It should not have a C if it's public. So it's saying that it's both public and redacted, public and confidential. It's also not the same document that is the attachment NTG-7 that we admitted through the spreadsheet. It's not the same document. 77, let's see, this one on the spreadsheet is a 77-page long document, while this one's 77 pages long, the one on the spreadsheet is 92 pages long. So they're just different documents marked with the same exhibit number. Then there's attachment NTG-7C Rev. That's how it's saved and titled in staff's box. Please look at that, staff. There's no exhibit number in the electronic title of the document. Again, so it's just the attachment number. It's physically marked with two different titles, both as Hearing Exhibit 601, attachment NTG-7C, and also as 601, attachment AOA-7C. It's also not the same document that was on the spreadsheet for the same reasons I just described. It's completely different page numbers. Then there's also attachment NTG-7C W label Rev. That's how it's titled in staff's box folder. So this is an executable file that's not titled or marked as such, contrary to paragraph 20 of attachment B to decision number 23-0532I. The document itself is marked as Hearing Exhibit 601, attachment AOA-7C, not NTG-7C. So I just want to highlight that those examples, that's two attachments to one exhibit. And those are the issues. I have spent personally probably about 8 hours looking at these problems. My staff here at the commission has spent a lot more than that. I'll just say I'm frustrated that we're in this position, that we're having to spend this time during the hearing to deal with these issues that we should never have to deal with. And frankly, staff has always been very capable of getting exhibits filed correctly. I've never had this issue with staff. I don't want to punish staff because I'll be honest, I don't think this is work that staff did. This is council's one that files the exhibits and is responsible for ensuring that the exhibits are correctly marked and filed and titled. And so while I don't want to punish staff for what I see as council's mistake, I am not going to admit these unless we get the stuff corrected. As you can see, just from the several examples I've given, if I admit these exhibits as is, we're going to have a significant amount of confusion in the record. So here is how we're going to handle this. I'm not going to go through each error. They're just too voluminous. We'll spend 2 days, 3 days in hearing doing that if we have to. Rather than wasting our time during the hearing, what I want to do is set aside time to address any other exhibits that staff wants to admit into evidence that are problematic through their box.com process after we have received all of the live testimony here today. If we finish all of the live testimony today, what I'd like to do is reconvene our hearing either tomorrow or Friday, but it will be fully remote because I'm not going to have everybody waste their resources driving downtown to deal with exhibit issues. So we'll either do it tomorrow on Friday and we'll be fully remote, and then we'll just go through those exhibits and figure out what's been fixed and what can come in and what can't. So I'm basically giving staff another opportunity to correct the errors so that evidence can be admitted into evidence. And I really like to encourage the parties, particularly the settling parties, if you would like to rely on this evidence to offer your resources to help staff's counsel get these exhibits correctly titled. All of you had no problems doing it. I mean, I'm not saying everybody was perfect. I mean, I think we probably had some problems, but they were acceptable enough that I didn't have to go through this with everybody else. So I'm hoping you can all bring your resources to bear to help staff. What I don't want is to then come back and have more problems to deal with the exhibits. So I think, at the end of the hearing, we'll talk about whether we're going to convene tomorrow to do that or whether we're going to convene Friday. It might, just depending on if we finish the evidence today, it might be a good idea to take tomorrow to give staff time and all of you to work together to fix these problems and then convene on Friday. And I'm certainly open to that option, but we can discuss that at the end of the hearing. I think it really depends on where we are with the evidence. Based on what the parties have indicated and the amount of time that they'll need for witnesses, I don't see any reason why we can't finish the live testimony today. Okay, so those are my preliminary issues. I want to give staff would like to say anything on the record. Council, to any of the issues I've raised, you're welcome to do so now. You don't have to, but you are welcome to. And then I also, after that, want to give the parties an opportunity to raise any other preliminary matters before we get started on the evidence.
Your Honor, obviously there are a lot of issues here, so I don't want to really, until I look at these things, comment on them, because again, I don't want to, well, obviously I want to get it right. So I think I apologize. I will take a look and we'll do whatever it takes to get these things fixed. And so I apologize, but in terms of addressing the specifics, I don't want to just shoot from the hip. I want to say something that's informed. And at this moment, if I were to say something, it probably wouldn't be fully informed. And so I don't want to do that. So I apologize.
That's fine. I'm just going to say that if we reconvene on Thursday or Friday and we still have these problems, I'm not taking any excuses. I'm giving you and staff another chance. And these issues have been highlighted, I think, at least 2 or 3 times before even coming into this courtroom today. and there will be no excuses. And I'm not suggesting that you are making any excuses right now, but council, your eyes need to be on these exhibits. This is not something to delegate.
I fully agree. I understand.
Okay. All right, so any other preliminary matters that we need to talk about before we get started on the evidence?
Yes, Your Honor. It's Mark Valentine for AM Gas. First, I have a head cold, so if you can't understand something, I apologize. AM Gas is going to waive cross of staff. And would like to reserve that time in case it's needed for the company. We also have a request to put on Mr. Levine live to address some of the settlement testimony that was put forth by the company. I've let the company know of this request in advance. They're opposed. They can speak for themselves. And the reason for this, Your Honor, is that we did not know the whys of the support for the settlement ahead of time. And there is some testimony concerning the motives of AM Gas in this proceeding that I think are unfair. And I think that Mr. Levine deserves a chance to respond. And I would refer you to Hearing Exhibit 118, page 33, beginning at line 7, where the company witness really delves into AM Gas's motivations and really questions what it's doing in this hearing. So that's the request. It won't be long testimony, but we would like the opportunity. Thank you.
All right, thank you. Mr. Valentine indicated that the company objects. So Mr. Cushing, would you like to state the company's position for the record?
Your Honor, the company's position at the outset was that settlement was filed on November 17th. November 20th was the deadline to file responses or support for or against the settlement agreement. Mr. Valentine was informed of that based on his position this morning that the responsive testimony of Mr. Levine is going to be based or responsive to settlement testimony that was filed on November 20th. The company would just reserve the right to rebut that testimony and put on a live witness to respond to Mr. Levine's response. It's clear.
All right, that I will allow, and therefore I will grant Mr. Valentine's and AM Gas's request. All right, are there any other preliminary matters?
Your Honor, for the UCA, I just wanted to make it clear that Mr. Corey Skluzak is in surgery today, or yesterday, I don't know. But so Dr. Scott England will be here to answer some questions relating to his testimony, and then Mr. Ron Fernandez will also be available.
Okay, thank you. Are there any other preliminary matters that we should address?
Your Honor, this is tied to one of our witnesses who is traveling today. My understanding is that they're unavailable between 11:30 and 4 p.m. due to travel, and that's for Mr. McKenzie. So I'm not certain if, I know we touched on it a little bit earlier that you may or may not have questions depending upon the flow of the hearing, but he is a witness that we may have to call at the end of the day.
Okay,
Or before 11:30.
sure, we can work around that. I'll just say, if I had to guess, Mr. Harrington and or Mr. Christopherson, I think, should be able to answer the questions that I have. But I don't know about other parties. I don't think any time was reserved for this witness from anybody else, so we will probably be in the clear. So it might be best to get Mr. Harrington on, and if he can't answer my questions, we might want to put Mr. Christopherson on after him, and then that way we'll know whether we need Mr. McKenzie to be called out of order.
Understood. Thank you, Your Honor.
All right, any other issues? Okay, let's get started on the evidence. Is the company prepared to call its first witness?
We are, Your Honor. The company calls Mr. Michael J. Harrington to the stand.
Hey, Mr. Harrington,
Good
you
morning.
could raise your right hand with me. Do you swear or affirm the testimony you will give in this case will be the truth?
I do.
Go ahead and take a seat. Will you just make sure that microphone is on?
Yeah, this one.
Yeah, don't
You hear me?
Yes, okay, the microphone is working. Please state and spell your name for us.
Good morning. My name is Michael Harrington, spelled Michael Harrington.
All right, that's what your witness.
Thank you, Your Honor. Mr. Harrington, by whom are you employed and in what capacity?
I've been employed by Black Hills Service Company. I'm the Director of Regulatory.
And did you prepare and have testimony filed in this proceeding?
Yes, prepared direct testimony, rebuttal testimony, and settlement testimony.
All right, and those hearing exhibits are 101, 110, and 118 respectively. Is that correct?
I have them here. I have printed copies. Yes, that is correct.
Perfect, and those have already been admitted into the record. Were you also involved in the settlement discussions as in this proceeding?
Yes, I was.
And are you a signatory to hearing exhibit 117, the settlement agreement that was filed in this proceeding?
Yes, I am.
Are there any corrections that need to be made to that hearing exhibit?
Yes, we have 3 corrections to the settlement agreement that over the last week we would like to correct. We work with the settling parties. And then so I'm prepared to walk through those 3 corrections.
Your Honor, I would request that we pull up hearing exhibit 117, Rev 1 from the company's box folder. And if we can scroll down just a little bit. The red line there. And can you take us through the purpose of this correction?
Okay, the first correction here is on paragraph 23. This paragraph discusses the implementation of the changes that are needed to the system safety and integrity rider. And about in the middle of the paragraph here, we've made some red lines to this language you can see on the screen. That the company shall make a compliance advice letter filing on 2 days business notice to implement the interim SSIR change. And this is an important change. It's needed because one of the aspects of this case, we are rolling in certain investments that are currently in the SSIR rider. And we need to time the implementation of rates so that there's no potential double recovery of those investments. And so timing the change of when base rates become effective and then this removal of these investments from the SSA rider, it's an important timing. And so this change aligns that and it avoids that potential double recovery.
And is that reflected in the pro forma tariffs that were filed as hearing exhibits 3 and 4, attachments 3 and 4, or appendices 3 and 4 to the settlement agreement?
Yes, those pro forma tariff sheets that we filed took into account this change in the SSIR rate. That would also be a part of this compliance file.
And can you take us through the second correction?
Okay, the second, yes, Mr. Kush, the second correction, I believe is on page 20, table 3. Here they're just categories these as technical errors, some slight number changes as we were reviewing the numbers and comparing it to our revenue requirement models. So we've made some slight corrections to the numbers on the table.
And can you take us through the third correction, please?
Okay, the third correction is on page 23. And in paragraph 57, this paragraph talks about the amortization period for rate case expenses. And that second sentence at the top of the page, it starts, if the amortization period is shorter than the period between effective date of rates in this case and BHCG's next rate case, the company will track the potential over collection and a regulatory liability. So we needed to strike that 2-year, that 2-year reference. That was an incorrect placement of that 2-year term. Those are all the corrections, changes we have to the settlement agreement.
Your Honor, we did provide these corrections to the other parties. We would move for the admission. We're not certain the best approach here because it's 3 separate pages that are Rev 1 as compared to the entire hearing exhibit 117. But we would move for the admission of these 3 pages.
Any objection? Okay, hearing exhibit 117 Rev 1 is admitted into evidence. And I'll just make a record that it will report the pages of hearing exhibit 117 Rev 1 that are duplicative of the pages in hearing exhibit 117 will replace the pages in hearing exhibit 117. Just for purposes of how I'm going to treat it and how we should all treat this. In other words, these pages will go in the place of the pages of the same pages of the exhibit that's been marked as hearing exhibit 117.
Thank you, Your Honor. Mr. Harrington, anything further that you wish to add regarding the settlement agreement?
Yes, first, just thank you for your honor for holding the in-person hybrid hearings. We appreciate being back in person. I brought a few friends with me today. In case we have some additional questions, Ms. Samantha Johnson is here. Mr. Doug Hyatt is here also, and Mr. Christopherson is here. So we do have a few folks here that can help if I'm unable to answer your questions. The settlement parties worked hard on the settlement agreement. Without going into too much details on the negotiations, we met multiple times, multiple rounds of discussions with the parties. We filed settlement testimony, so I won't go into all of that, but the settlement agreement, it's a comprehensive package that resolves all the issues except for one. There's one minor, well, I wouldn't call it minor, there's one issue that's still under contest. The settlement agreement, we believe, results in just and reasonable rates, and we respectfully ask that the commission approve our settlement agreement without modification.
Thank you, Mr. Harrington. This witness is available, Your Honor.
All right, I think AM Gas is the only witness that's going to be cross-examining Mr. Harrington. Mr. Valentine, are you ready for cross-examination?
Yes, thank you, Your Honor. Good morning, Mr. Harrington. For the record, I'm Mark Valentine, and I'm here on behalf of AM Gas. I have some initial questions to clarify where the numbers in the settlement testimony come from. There's some testimony about GCA rates and so forth, and if you need to defer these questions to Mr. Christopherson, just let me know. That's fine. Do you know if the numbers are based on the red line tariff? It's hearing exhibit 117, appendix 4. You know if the settlement numbers are based on your filed tariff in this case?
Well, Mr. Valentine, there's a lot of numbers in the settlement agreement. Could you help me?
Yeah, happy to. So for example, if you turn to hearing exhibit 119, page 12,
Who is 119 associated with Mr. Valentine?
It's the settlement testimony of Mr. Christofferson.
Thank you. And can you say the page one more time for me?
Sure. The page number is 12. And I'm just looking at MJC-S1, that table there. So that's current, it says current GCA rate per therm and proposed GCA rate per therm, and then the rate change per therm. And I'm just wondering, Mr. Harrington, if you know whether those numbers are based on the filed tariff.
Well, one more clarification, is the file tariff, Mr. Valentine, referring to the pro forma tariff sheets?
Yeah, well, I mean, for example, hearing exhibit 117, appendix 4 has the proposed changes in it, and it sets forth GCA rates and so forth. And I'm just wondering if that's a place where I can go to find the source for the numbers that are in that table. So for example, down here, it has total gas cost adjustment rates there. Are those the rates that are used in the table? And again, you know, if I need to speak with Mr. Christofferson about this, that's fine. I'm just trying to be efficient here.
Yeah, I'm generally familiar with those numbers, but it's probably better safe just to ask Mr. Christofferson to go through that table.
Okay, thank you. I'm happy to do that. And I'll just move on. Mr. Harrington, can we agree that it is important to have sound price signals for customers?
I'm thinking about your question. I'm not so sure I understand what you mean by sound price signals.
Well, a price signal that accurately reflects the cost of service.
Okay, those are two separate issues. I think rates that are reflective of a cost of service are a very important aspect of rate design.
Okay, and you know, would you agree with me then that the rate that a customer pays sets a signal to the customer about the cost of service?
I think the rate, the rate would set a signal to the customer in part to the cost of service. You know, oftentimes the rate that a customer pays is not entirely cost-based. There are oftentimes other factors that come into play, but I do think the rate itself predominantly reflects the cost, the cost of service to that customer.
Okay, and it should be a goal that rates reflect the cost of service rendered by the utility, right?
I would say that is one aspect of rate design, but not the single aspect of rate design or the single goal.
Okay. Now I'd like to turn to the west slope with storage area, and that GCA area was created in a settlement in a source gas proceeding, proceeding number 23AL-0046. That's right, isn't it?
That's correct.
Okay. And are you surprised that AM Gas, as a settling party in that case, is seeking to maintain the benefit of its bargain that it negotiated in settling that case with staff and UCA? Is that surprising to you?
No, I wouldn't say that's surprising. I'm aware that that was, an issue of AM gas in that, rate case, about 10 years ago. And, I'm not surprised AM gas, for reasons I stated in my testimony, continue to advocate for the carve out of those specific storage assets.
Okay, so it is the policy in Colorado, is it not, that companies like AM Gas are able to procure commodity for customers and ship it over utility-owned pipelines?
I don't know if I would agree it's a policy. They are certainly allowed to, and Tariff, it possibly is even allowed under legislation, but I'm not sure on that. But it is certainly allowed under our tariffs that customers can elect, if they so choose, to procure their gas outside of the utilities. And those customers would, oftentimes they contract with an agent such as AM Gas, and AM Gas would then procure their gas on their behalf. I don't know if I would say it's a policy, but it is certainly allowed under our tariffs, and we have several customers who choose to do so.
Okay. All right, let's go to your comments about AM Gas, and I'd like to bring back Exhibit 118, beginning on page 33, line 7. Now, here is where you really question the motivations of AM Gas in this proceeding, and you say that AM Gas is not a customer of Black Hills and that it doesn't represent any customers in this proceeding. Do you have any personal knowledge of AM Gas's relationship with its customers?
Well, I have knowledge of what AM Gas's role is consistent with our tariff. So under our tariff, a customer will elect to choose to purchase their gas through their own means. And if that customer elects to do so, they oftentimes, like I mentioned, will contract with a gas marketers like AM Gas. AM Gas then acts as their agent. And so our tariffs define this relationship between the customer who has elected to take service as transportation and who they choose as their agent. And so AM Gas is an agent. AM Gas is not a customer of Black Hills.
And I'm taking that that's a no. You really don't have any personal knowledge about how AM Gas treats its customers, how it acts as the agent for its customers, do you?
I am familiar with the relationship or the interaction AM Gas has with the company in the way they nominate gas and take service or flow gas. I do not have knowledge of AM Gas's interactions with our customers.
Okay, let's, I actually have very little left for you. Let's go to page 34, line 13. Now, okay. Now, you say here that the GCA, I'm looking lines 13 to 14, you say that the GCA consolidation benefits all affected GCA customers. Do you see that?
I do.
But that's not really the case because some customers are going to see a price increase, aren't they?
It is true that all customers under this new Eastern and Western GCA proposal will benefit. Yes, some of those customers would see a slightly higher GCA, as explained by Mr. Christopherson in his settlement testimony. But this Eastern and Western GCA structure, it actually allows more customers that option and more fairly allocates storage costs to all the customers who actually are benefiting from that storage.
Okay. Those are all the questions I have, Mr. Harrington. Thank you.
Thank you.
I think that's everybody who's gonna be cross-examining you, Mr. Harrington, so I am gonna jump in with my questions. Can you hear me okay?
Yes.
All right. So let's pull up hearing exhibit 117. And I'm gonna ask you specific questions about the settlement agreement. And I put these together before seeing any revisions to the settlement agreement, so I don't think, hopefully my questions impact those revisions, but if there is a connection, I'm gonna ask you just signal for me so we pull up the right document. Okay, so hearing exhibit 117, let's go to page 15. All right, paragraph 35 is what I wanted to talk to you about. All right, so it says in paragraph 35 of hearing exhibit 117, for purposes of the settlement revenue requirements, annual depreciation expense shall be calculated by applying the settled depreciation rates to the 13-month average plant and service balances for the period July 1, 2022 through June 30th, 2023. I just wanted to see if I can get some clarity on the reference to the settled depreciation rates and where I can find those in the settlement agreement.
The rates themselves, I don't think you can find in the settlement agreement, but it is, this paragraph is referencing back to paragraph 33, which talks about the settled depreciation rates. And so the parties or the settling parties agreed to the depreciation rates that was provided in our direct testimony from Mr. Spanos. So the actual rates themselves are in an attachment to Mr. Spanos' direct testimony. And so that is what we're referring to here.
Okay, thank you. That's very helpful. And then just going back to paragraph 35. So I just want to make sure that there wasn't an error, that it was intentional, that the parties refer to the 13-month average plant and service balances rather than the 13-month net average plant and service balances. Was that intentional, that to exclude the word net?
No.
Okay.
The depreciation rates do apply to the net in the company's books and records, when we apply new depreciation rates, they're applied to the gross plant balances. So net was not necessarily intentional to exclude. There's a retirement component in the depreciation in plant balances. That oftentimes when we talk about gross plant, we netted up retirements. But that's how it's applied in our depreciation books and records.
So to be more accurate, it should say 13-month net average plant and service balances in paragraph 35. Am I understanding that correctly?
It's not the net, it's net gross plan, it's not net plan, if that makes sense. So in rate base, you take your gross plan, then you take out your accumulated depreciation, and so that often is what we call net plan. Depreciation rates are applied to the gross plan amounts.
Okay, all right, thank you. And let's go to page 22, same exhibit, hearing exhibit 117. Right, so that very first sentence says, actually, hold on. Let's see if we can just get that full paragraph 56 on the screen. All right, so in the last sentence of that paragraph, it says the settling parties also agree that the allocation of rate case expenses among base rate areas shall be as proposed by staff. So I just want to make sure that I'm tracking correct staff proposal. Is this intended to reference staff's proposal that's described in the last sentence of paragraph 55 on page 22 of hearing exhibit 117? And we can scroll up. And that's where staff, which says staff also recommended reallocation of the estimated rate case expenses between the three rate case areas so that 29.71% is allocated to RA1, 23.65% is allocated to RA2, and 46.64% is allocated to RA3. Is that what is intended to be referenced in the last sentence of paragraph 56?
Yes, it is.
Thank you. Go to page 26 of hearing exhibit 117. Paragraph 69, I think we've got it all on the screen there, great. All right, and the last sentence of paragraph 69 says, additionally, UCA staff and the company agree to work collaboratively to maximize percentage of income payment plan PIP subscriptions in all three base rate areas with a particular focus on RA2. How does the UCA staff and the company plan to maximize PIP subscriptions?
Well, we don't have anything worked out yet. We have some ideas, and our internal team, our internal marketing team and our low income team have started to gather some ideas. But what we've, one of the concerns among the parties and the company was the impact that this rate change will have for rate area 2, specifically residential customers. So in recognition to that concern, we've kind of committed to working with staff and the UCA on making sure that these customers are informed and understand of the benefits that are available to them. So we don't have anything worked up yet specifically as to how we're going to do that. But we plan on coming up with some ideas to make sure that, again, these customers, they understand the energy assistance benefits, the energy efficiency benefits. And as we go through that, there may be some changes that we might need to make to our PIP. Right now we have a pretty low funding rate for our PIP. And so we're looking at, we potentially might need to increase some funding for that benefit to those customers. So we don't have anything worked out yet, but we do have our teams working on it. And we have done some, this isn't a novel concept. We've worked with staff in the UCA on issues like this in the past. Kind of back when Storm Uri happened a couple of years ago, we had kind of similar efforts where we would work with UCA and staff on messaging and customer information. So this isn't a new concept. We've done this before, but we do intend to work with staff. Our team is working on some ideas.
Okay, I'd like to get a little bit more of a fulsome record on what PIP even is. So why don't you tell us about the company's PIP program?
Sure. Percentage of income payment plan, all utilities provided. It's required under commission rules at year. Customers who are applied for LEAP, which is the federal energy benefit for natural gas heating. Customers who are eligible for LEAP, they will get, assuming they're enrolled in LEAP, they will get benefits from LEAP for energy assistance. They are also eligible, and customers can also apply for our PIP program, which provides also some additional bill assistance. There is a complicated formula for how the benefit is determined, but it is the customers receive a monthly benefit on their bill. The PIP program is funded by all of our customers through a separate surcharge on customer bills. And currently we have, oh shoot, I forget the number of customers. Last year we saw, due to the high pricing last year, we did see a significant increase in the customers applying for the energy assistance. The annual leave cycle, the annual enrollment here is up in November. And so we're expecting to see a similar amount of customers needing assistance. And so in our efforts with staff at the UCA, I think this will be very helpful for these customers in Red Area to really inform them about these energy assistance benefits that are available to them.
So you said that customers would receive a benefit on their bill. Tell us what you mean by benefit.
Reduced bill. They receive, it's essentially a bill credit that shows up on their bill. The calculation is determined on an individual basis based on their percentage of income, which is hence the name, percentage of income payment plan. And so the benefit that a customer gets as a credit on their bill is kind of specific to that customer. And we apply the LEAP funds as a credit to their bill, and then we apply this PIP credits as a reduction to their energy bill.
So the PIP program is available, essentially, if I'm understanding correctly, only to customers that meet certain income requirements.
Correct.
And we've typically referred to that as sort of income qualified customers.
That's correct.
So what about customers who are gonna struggle with their bills, but may not meet income qualifications for this program or other programs? Is there anything that any programs the company can do to help those customers with their energy burden?
Yeah, there's several others. Energy Outreach Colorado is an organization that also receives funding to help customers. And so they have similar criteria, but my understanding is they do have a little more flexibility than the LEAP requirements. So there's Energy Outreach Colorado is another organization that can help customers. We have customers, we have our own organization, we call it Black Hills Cares. So this is funds that the company puts forth and can help customers who apply and need help. Customers have ability to get on budget billing, which is very helpful. That smooths out customers' bills.
Let's explore that. Talk about budget billing. What is it? What does it look like?
Sure, especially for a natural gas customer, their bills vary widely throughout the year. And we're now in the heating season, which we call it, November, December, through March. We call it the heating season where their bills are typically a lot higher, due to heating their homes. And then in the winter, or in the summertime, their bills are usually, much smaller. And so a budget billing, what it does is it smooths out the swings of their bill, and customers would pay a flat bill throughout the year. There wouldn't be big swings ups and downs. So we find customers really enjoy that option, because it really helps them plan and manage their individual budgets.
So how do you determine what the flat amount would be that the customers would pay monthly for budget billing?
It's based on their, a review of their historical consumption. So, we look at I believe we look at their past 12 months, historical usage and average their usage over a historical, period. And then that is what is used to set their monthly fixed bill going forward. There is a true-up process involved where if a customer has a significant change to their usage under the fixed bill payment plan, that we would true up, and that would get carried over to their next year's budget bill amount. But we base it off of their kind of historical usage consumption.
All right, thank you. Still on hearing exhibit 117, let's go to page 28, paragraph 73. All right, I'll go ahead and just read this. I've got a number of questions for you. So paragraph 73 states that the settling parties agree that it is in the public interest to have the settled base rates become effective as of February 1st, 2024, and thereby avoid the potential customer confusion of an interim filing to place provisional rates into effect on February 13th, 2024. So I think the first question I have is about that first sentence, just to make the record clear. I understand that the provisional rates that are referenced in that sentence that I just read is essentially a reference to the provisional rates that were approved by decision number R23-0532-I. Am I understanding that correctly?
Yes, I'm just verifying your decision number. I think that is, I touch on this in my settlement testimony.
If you would like to verify that, let's pull up hearing exhibit 118, go to page 30, and we'll refresh your recollection. You can look at lines 15 to 16.
I am there, and that is correct.
Okay, thank you. So let's go back to 117, same page, which was page 28, paragraph 73. And the second sentence in that paragraph says, to this end, the settling parties recognize and request that the commission issue a final decision approving the settlement agreement without modification, such that the company may make its compliance tariff filing on or before January 29th, 2024, i.e. on at least 2 days business notice. So I can tell you that while it is possible, it's highly unlikely that the commission can issue a final decision before January 29th, 2024. By my estimation, they'd have to issue it by January 26th, which is Friday. January 29th is a Monday. It'd have to be issued before you could actually file the tariff. So I'll just sort of let you know that I just don't think that that's likely. Unless essentially there are no exceptions filed in this case. To account for exceptions, my decision would have already had to have issued last week before a hearing. So anyway, I want to give you some a reality check on that, and then let's go back to the testimony to what's in the settlement agreement in light of, this unlikelihood. that you're gonna have a decision in time to get that tariff filing done within the timeline that the parties have agreed to. I just want to get a sense for, really, how firm is the company on wanting to go ahead and put provisional rates into effect if the commission can't issue a decision in time for the company to make the January 29th filing.
Yeah, well, Your Honor, we agree with your concern. We've talked about it with the selling parties. And we have a proposal.
Okay, let's hear it.
Because we anticipated you may have some concerns with that date. I think from our perspective, the issue of customer confusion is still important. And under the current framework, we would potentially implement provisional rates on February 13th. Those would then be trued up and then the final rates be implemented. So there's potentially 3 different rate changes that would occur, all for the same outcome. So we would like to avoid that. And I think the settling parties would like to avoid that as well. So our proposal, our option is if the commission cannot issue the decision at that time, we would recommend or propose a slight change to the provisional rates that we had agreed to earlier. And instead of implement the provisional rates that we had in that decision, we would instead implement provisional rates that are based on the settlement rates. That way, assuming there's no modifications, there would be no true up that would need to occur. And that would give the commission additional time if they so need to issue their final decisions. And so implementing provisional rates on February 1st that are equal to the settlement base rates is the alternative option.
Okay, well, I think that's potentially a really good option. Obviously, I haven't made my decision on the rates that are being proposed in the settlement agreement, but if they are approved, that would certainly avoid customer confusion and having to true up, which is no small task, and the company would be paying interest on any over collected amounts. And as I'm sure you're aware, the provisional rates were higher than the settled rates, so the company would definitely be paying interest if we had to do a true up using those provisional rates.
Yeah, we would love to avoid that customer confusion.
Yeah.
I think, yeah, and so I think this is an option. Like I mentioned, over the last week, we've been discussing this. We anticipated you may have some concerns with that date. So we did speak to the parties, the settling parties. I believe we have consensus that this is a viable option that could help alleviate that concern of having these multiple rate changes for really the same proceeding.
All right, let's go to page 30 of hearing exhibit 117. Paragraph 79. So I want to look at the second sentence that says the company shall provide to UCA documents for the QSP process. I'll just say I find this very vague, and I'm hoping you can shed light on what is intended with this sentence, such as what type of documents this language is trying to refer to, and what is meant generally by the QSP process.
Yes, so we have a QSP's quality of service plan, and our quality of service plan right now expires at the end of 2024. And so what we have agreed to is over the next year, we will work with commission staff to revise our QSP, and while it may seem minor, it is I would say, a significant aspect that the company is agreeing to refile and extend our QSP. It expires, and I think you could argue that there's no requirement to continue, so that was a pretty significant concession on our part. But there have been a number of changes that would need to be implemented since the last QSP. Our business has changed a little bit. There's some different priorities, some different policy objectives that we would agree to work with staff to try to develop and revise what those metrics would look like. So that's the process that we have envisioned. By no means, I mean, we're excluding the UCA from that process. This was really a staff issue that staff kind of raised. And so kind of at least what I interpret that provide the UCA documents is really the metrics, the savings goal, or the goals that we kind of ultimately come up with. And we would certainly inform the UCA, sure the UCA is informed, included on kind of those process that we have with the commission staff.
That's all my questions, and that also means that I do not need to ask Mr. Christopherson any questions or any other company witness. So, Mr. Cushion, do you have any redirects?
Just a couple questions, Your Honor. I see we're approaching the 10:30 hour. I wonder if we might take a break now, and I can tighten up these issues.
It makes sense to go ahead and break, take our mid-morning break now. I'm gonna make it just a little bit longer. I think we've got the time, and I don't want to rush you if you need a few minutes. So why don't we break until 10:45?
Your Honor, before we
Yes.
break,
Yes.
I believe you just said you have no other questions for the other witnesses.
That's correct.
So-
Mr. Harrington answered all of them.
If we can use this break, we'll also let our witnesses know.
Sure.
Awesome. Thank you, Your Honor.
All right, we'll be in recess until 10:45. Only if you want to. You're settled. Right, we'll go back on the record. Mr. Harrington, I'll just remind you, you're still under oath. We're about to begin redirect. I see Mr. Valentine. Did you have something you wanted to say? Because you unmuted.
Thank you, Your Honor. Mr. Kosian indicated that he was going to get with his witnesses because you had no more questions, but Mr. Harrington deferred a couple of questions to Mr. Christofferson, which I would like to ask him.
Okay, yep, you are correct about that. So we will, I'll just, ask Black Hills to make sure that he is still gonna be made available.
Yes, Your Honor, I do apologize. I meant our witnesses that are on Zoom, but won't be questioned. Mr. Christofferson is here in the hearing room with us this morning.
Okay, great. All right, you can begin your redirect whenever you are ready.
Thank you, Your Honor. Mr. Harrington, you were asked a series of questions by Mr. Valentine regarding sound price signals, the price reflective of cost of service, rates that are paid, the goals to reflect the cost of service in rates. Can you explain whether the current price structure in the Western Slope with and without storage GCA area sends sound price signals?
It does not. I'd say it sends a mixed price signal. The current structure sends a mixed price signal. The structure right now in the Western Slope, there are two aspects of storage. One aspect is the cost of the storage, which is directly assigned to a subset of customers. The other aspect of storage is the price arbitrage that happens with storage, whereby the company, through our gas supply plans, we can inject gas into storage and withdraw it. We use that to help balance the system. We use that to also provide for some price arbitrage. That benefit is provided to all customers in the Western Slope. So the current structure that we have right now provides actually a mixed price signal. And so by eliminating this specific carve out, actually provides a better price signal to the customers in Western Slope.
Mr. Valentine also asked you about the settled 2013 rate case. Do you recall those series of questions?
Yes.
Based on your experience, when parties enter into an agreement, how does that impact their positions in future proceedings?
Well, there's always language at the end of settlement agreements where the parties agree that none of the issues are precedential and parties are free to make arguments in future proceedings that may be different. And so, I think that just because the storage carve out was created in a settlement agreement, by no means that we can't change it here.
And so just to take it or provide an example, just because the parties agreed to a February 1st implementation date doesn't mean that in our next rate case that we can hold the UCA to the fire and say rates must be implemented on February 1st.
That's right. And again, there's usually a lot of boilerplate language at the end of the settlement agreements that say just that.
Mr. Valentine asked you several questions about the testimony that AM Gas is not a customer. Are you aware of any customers in this proceeding of Black Hills Colorado Gas?
Yes, we have Walmart. Walmart is a customer of Black Hills, and Walmart has several stores and locations in the Western Slope.
And Walmart signed or entered into the settlement agreement as well?
They did.
Nothing further for this witness, Your Honor.
All right, Mr. Harrington, thank you for your testimony. You may step down.
Thank you.
Black Hills can call its next witness, which I'm guessing should be Mr. Christofferson.
Yes, Your Honor. Black Hills calls to the stand Mr. Matthew J. Christofferson.
Good morning. Please raise your right hand. Do you swear or affirm the testimony you will give in this case to be the truth?
I do.
Okay, go ahead and take a seat. You get comfortable, state and spell your name and make sure you're speaking into the microphone.
Sure. My name is Matthew Christofferson, MattheWChristoffoff.
Your witness, Mr. Goshen.
Thank you, Your Honor. Good morning, Mr. Christopherson.
Good morning.
Please state your current place of employment and your title.
I'm employed by Black Hills Service Company as manager of regulatory.
And did you prepare and cause testimony to be filed in this proceeding?
I did.
And did you prepare what's been previously admitted as hearing exhibit 109, your direct testimony and attachments?
Yes.
Did you also prepare and cause to be filed hearing exhibit 116, your rebuttal testimony and attachments?
Yes.
And finally, did you prepare and cause to be filed hearing exhibit 119, your settlement testimony?
Yes, I did.
This witness is available for cross-examination, Your Honor.
Mr. Valentine, I believe you're the only one who would like to cross-examine this witness. You may begin whenever you're ready.
Thank you, Your Honor, and I hope to not take long here. Good morning, Mr. Christopherson. I'm Mark Valentine on behalf of AM Gas. And I just have some questions about some of the tables that you have in your settlement testimony. So if we could turn to your settlement testimony, hearing exhibit 119. And I'm on page 12. And I'm looking at MJC-S1, and I don't know if you were in the room for my questions to Mr. Harrington, but my questions are, you state here that the current GCA rate per therm and the rate of change per therm and the proposed GCA rate per therm are in this table. Where did those numbers come from? Are those from the tariff that you filed for this case?
The current GCA rate per therm that's reflected in table MJC-S1, those current GCA rate per therm, those are derived from GCA rates that were effective at the time of the filing of this direct case.
Okay, so these are not, in fact, the current GCA rates per therm, are they?
They were current as of the time of the direct case filing.
But okay, but they're not current now, right?
Those rates are not in effect as of today.
Okay. If we could call up hearing exhibit 702, please. It's in my box. Now I'll represent to you that this is an excerpt from the current tariff. And if we could scroll down to one of the following pages. So this is the 18th revised sheet number 13, and the file tariff you use is considerably older, right? I mean, I think that file tariff was the 14th revised sheet. Is that right?
Looking at the hearing exhibit 117, appendix 3, page 1, tariff sheet number 13 is the 14th revision.
Okay. And so these are the rates that are currently in effect, right?
Mr. Valentine, can you be more specific? We have one exhibit on the screen.
I apologize, Your Honor. Hearing exhibit 702 GCA rates are the rates that are currently in effect. Is that right?
If you'd be able to scroll down a bit to the tariff date at the bottom right-hand corner. Yes, those are are the GCA rates that are in effect today.
Okay, so let's go back to your testimony and go to page 17.
And Mr. Valentine, I'm still in 119. I just wanted to make sure that's
Yeah,
the right.
I'm in one. Thank you. Yeah, I'm in 119. So this table is also based on the rates that you filed that you just referred to, not the rates that are currently in effect. Isn't that right?
The estimated bill impacts reflected in table MJC-S2 is inclusive of rates that were in effect at the time of the direct filing.
Okay.
Or I should specify it, and that it would be for the current average monthly bill.
Okay. So now I think currently the company develops cost of service models for all of its rate areas, right?
The company develops cost of service models, and they are demonstrated and displayed by the various base rate areas.
Okay, and that's true for each GCA, current GCA area, right?
Can you restate the question?
Sure. Each GCA rate area has a different cost of service presently, right?
Each GCA is developed into a separate rate using the various inputs, including.
Yeah, I was just going to say, I'm not trying to trick you or anything. I just upstream pipeline costs, for example, vary between GCA area. Isn't that right?
Our GCAs typically do have, our existing GCA areas typically do have different upstream pipelines. That's
Okay.
accurate.
Okay. So let's look at this table that's on the screen here. You see that there is a proposal under the company's proposal to consolidate. There are certain areas that are going to see substantial decreases in GCA rates, right? And that's a portion of base rate area 1, which is at 15.3%. And then there is also a significant decrease for a portion of base rate area 2, which will see a 13.6% decrease. Isn't that right?
I see the line items you're speaking of. The significant decreases are attributed to those communities being part of the north-southwest GCA area, not necessarily reflective of the base rate area they're in.
Okay. And the increases that are shown on this table are for different regions of the company's service territory, right?
Yes, there are some GCA areas that will see an increase.
And effectively, the customers in those areas with increases are going to be paying for the decreases in the other areas, right?
I don't think that's an accurate statement.
So this is not the company's GCA costs are not a zero-sum game, if you will.
The total cost the total GCA cost would be distributed, would be equal through the current rates, and they'd be the same costs as in the proposed Western and Eastern GCA.
I'm sorry, I didn't understand that response. Could you repeat that, please?
Sure, so the total cost of gas, it would be equal under the north, southwest, the western, and the central GCA areas that we have today. That same pool of money would be allocated in a different way under the western and eastern GCA proposal.
Okay, that's fine. That's great. That's all I have, Your Honor. Thank you.
All right, thank you. I don't have any questions for this witness. So Mr. Ocean, do you have any redirects?
Just a couple of questions, Your Honor. Mr. Christofferson, is it common practice to use current rates that were effective at the time of filing for bill impact analysis in a rate proceeding?
That's my understanding, that it's helpful to use the current rates that were in effect as of the time of filing, so there's a consistent record of bill impacts as the rate case proceeds.
And so those bill impacts do not get updated with rates as rates change during the 9 months, 12 months of a rate case proceeding, do they?
That's correct. Our rates are not different throughout the course of this proceeding. There have been numerous rate changes since our May 8th direct filing that are not reflected in the bill impacts.
And can you explain why that's practice at the commission?
I think that's practice so that there's a consistent basis and there's a train of logic so that there's an understanding and can isolate specific pieces of the rate case that may have an impact on rates so that you are not introducing additional factors, additional rate changes that are not impacted through the rate case, such as a DSM rider, an SSIR rider, so that those changes that may have happened throughout the 8 or 9 month case of the rate case are not conflated and confused with the specific requests of the rate case.
And maybe it's just clarification, but there was a series of questions about the class cost of service studies and whether they were done for base rate areas and GCA areas. Does the company do class cost of service studies for GCA areas?
No, there are no class cost of service studies for GCA areas.
And so they're done at the base rate area level?
That's accurate.
Can you explain why that is?
The cost of service studies, that's really developed in looking at the base rates that you're trying to modify and that will be impacted through a rate case. The GCA changes, there is no cost of service study associated with that. It is simply just looking at a change in the gas costs and moving those about and developing rates for those customers.
All right, and so kind of turning back to hearing exhibit 119 and the two tables that were discussed with Mr. Valentine, table MJCS1 and table MJCS2. The intent of these tables was, and the reason that current rates were, or you used rates that were filed at the time of filing, is to provide a comparison of what the outcome would be to where we initially filed this proceeding or what we initially filed?
That's accurate.
Nothing further for this witness, Your Honor.
All right, thank you.
Your Honor, sorry.
Hearing exhibit 702, because I was going to ask you about that.
Yes, thank you, Your Honor. I would move for admission.
Any objection to the admission into evidence of hearing exhibit 702?
Your Honor, the company would propose that rather than having an excerpt of the tariffs, that an entire complete copy of the tariffs should be admitted or move for administrative notice. We do have a copy of the entire set of tariffs in the company's box.com folder as hearing exhibit 120.
Why don't we get that opened up on the screen? And Mr. Valentine, do you take any issue with having the entire tariff admitted rather than just a few pages?
No issue. I was just trying to not introduce 200+ pages, Your Honor.
This is the one great thing about doing it all electronically, is that the maps on trees. This is gonna be added to the record electronically. Okay, why don't we just scroll through a few pages? I just want to make sure Mr. Valentine has a chance to do his own internal comparison and make sure it's the same document, the document that we all think it is. Mr. Valentine, do you know what page?
Yes, Your Honor. I think if you go down to maybe page 9 or thereabouts, a little further. Yeah, this is good. Yeah, this is fine, Your Honor. I appreciate it. Thank you.
Okay, and I'll just let the record reflect that we were on page 14 of hearing exhibit 120, and that reflects at least some of the rates and information Mr. Valentine discussed with Mr. Christopherson that was in the document marked as hearing exhibit 702. So there being no objection to the admission of hearing exhibit 120, I will admit hearing exhibit 120.
Thank you, Your Honor.
All right, Mr. Christopherson, I think we've finished your redirect, so you may step down.
Thank you.
All right, does the company have any more witnesses?
No, Your Honor. Not at this time.
Okay. All right, looking to our joint witness examination matrix. As I've indicated, I don't have questions for Walmart's witness, and nobody has indicated they have questions for Walmart's witness. Turning to the UCA's witnesses, nobody has indicated they have questions. I do have essentially one question for both, the same question for the UCA and staff witnesses, and I think maybe just for efficiency's sake, I can let you know what that topic is. I know we've got one person here that could testify. Really what I wanted to sort of follow up on is the UCA and staff's thoughts on how the company can maximize PIP subscriptions, which is the language that's in the settlement agreement. I heard from the company on what they're thinking, and I think it might help our record to hear from the UCA and staff on that. So that's really the only thing I want to explore with staff and the UCA's witnesses. So I guess I'll turn to the UCA. Is that something your witness who is present here can address?
Absolutely, Your Honor.
Okay.
UCA would call Cindy Schoenhout to the stand.
Okay. Good morning.
Morning.
When you are ready,
I'm ready, thank you.
raise your right hand with me. Do you swear or affirm the testimony you will give in this case will be the truth?
Yes, I do.
All right, go ahead and take a seat and state and spell your first name for me.
Okay. My first name is Cindy, Cindy. My last name is spelled Schonhaut.
Counsel, you can proceed. Thank you.
Ms. Schoenhout, who is your employer and what is your position?
I'm the director of the Office of the Utility Consumer Advocate.
All right. And what's the purpose of your appearance today on behalf of the UCA?
So my purpose here is to talk about why the UCA joined the settlement agreement, and I'm standing in large part for Corey Skulzak, who is not available.
Thank you. Your Honor, Ms. Schoenham is available for your questions.
All right, thank you. Let's pull up hearing exhibit 117 and go to page 26. I don't know that we'll need it, but it couldn't hurt to have it up. Get paragraph 69 on the screen. All right, so in paragraph 69 of hearing exhibit 117, the last sentence says, additionally, UCA staff and the company agree to work collaboratively to maximize percentage of income payment plan, PIP, subscriptions in all 3 base rate areas with a particular focus on RA2. I heard from the company on the company's perspective on what that might look like, and I'm hoping that you can provide the UCA's perspective on how you can work collaboratively to maximize PIP subscriptions.
Thank you, Your Honor. The PIP subscriptions are for the percentage of eligible and qualified consumers to participate in the PIP program is a low number, which is true across the board for all government benefits of any kind. So the concept here is to focus on rate area 2 because that has a high number of income qualified consumers, and to market and do education and outreach to consumers there to enhance the number of consumers that subscribe to the PIP program. So for example, the company has some really excellent marketing communications people who have the expertise that we don't have at the UCA, to work together, learn from them, they learn from us, to work together to focus on rate area 2 consumers who are income qualified.
Well, what do you envision that looking like, this working together? How do you think that, I guess maybe I'll put it differently, how do you think that PIP subscriptions can be maximized?
So Mr. Harrington, as he explained, this is sort of a new effort, just something we put in the settlement agreement and had not previously talked about, as to how one can increase subscriptions to the PIP program is something that is not in the UCA's expertise as a consumer advocate, but there are people who this is what they know how to do. They know how to do the outreach and education kind of on the ground, grassroots, whether it's in religious organizations as a church or other efforts in conjunction with the OC, how to market to consumers, essentially, the PIP program.
And were you referring to EOC, Energy Outreach
Yes.
Colorado?
Yes.
Okay. All right, well, that's all the questions that I have. Ms. Singer, do you have, Singer Nelson, do you have any redirect?
No, I don't. Thank you.
Okay. And I'll just note again for the record that nobody has indicated that they wanted to cross-examine this witness. So you may step down.
Thank you.
All right, now let's turn to staff. We've got Ms. O'Neill listed, and AM Gas listed is wanting to cross-examine Ms. O'Neill. So I want to turn to staff's counsel, Mr. Opp. Are you ready to call your witness?
Your Honor, I waived at the beginning. I won't have any questions for Miss O'Neill.
You did waive that. I have a note here, but I think I'm going to go ahead and need to ask the same questions that I just reviewed with our last witness. So, Mr. Opp, let's go ahead and get your witness called.
Thank you, Your Honor. Staff calls Aaron O'Neill to the stand.
Good morning. You raise your right hand with me. Do you swear or affirm the testimony you will give in this case will be the truth? Put your hand down, state and spell your name.
My name is Erin O'Neill. It's ERINO''NEILL.
Mr. Ott, you can go ahead and introduce your witness.
Thank you, Your Honor. Good morning, Ms. O'Neill. How are you?
I am well. How are you?
Doing great. No, I'm fine. Thank you. I think we want to just update one thing. What is your current position with staff now?
My current position with staff is the Deputy Director of Fixed Utilities.
And congratulations. And you also, did you cause prepared settlement testimony in this proceeding?
I did.
Okay. With that, Ms. O'Neill is open to Your Honor's question.
All right, thank you. So, Ms. O'Neill, I think you probably heard the questions that I just asked the last witness and the related questions I asked company witness, Mr. Harrington. But we'll go ahead and just pull up the exhibit and page number just for completion of the record. Hearing exhibit 117, page 26, paragraph 69. And this is where in the settlement agreement, the parties additionally, it says additionally, UCA staff and the company agree to work collaboratively to maximize the percentage of income payment plan PIP subscriptions in all three base rate areas with a particular focus on RA2. How does staff anticipate the company being able to maximize PIP subscriptions?
Well, I agree with everything that the company and UCA has said about this. I think it's not clear exactly what that's going to look like. Part of this is a discussion to brainstorm and figure out what are the ways to maximize communications, whether that's through additional emails or whatever. And I think part of the idea is for us to get in a room and think about what are the touch points the company has with customers now in DSM programs or whatever, and whether there's ways to leverage what the company's doing. I would also add that the what's called LIRAC, the Low Income Rate Assistance Coalition, which is a coalition across all of the utilities in the state that work on low income qualified type issues, will be, I think, also a benefit to this question of, and Black Hills is a participant as our UCA and staff in that coalition to try to work on these issues writ large. So I think there's also some learning from other utilities as to what works well and what doesn't, and vice versa, if there's lessons that we can learn from Black Hills with this focus to bring to that coalition to benefit the other utilities in the state. So I think that's the idea, is to focus on this and thinking about whether there's other creative ways to leverage the company's current assistance programs and communications with customers to focus on this, PIP enrollments in particular.
Great, thank you. As there will be no cross, I will ask Mr. Opp, do you have any redirect?
I do not, Your Honor.
All right, Ms. O'Neill, thank you for your testimony. You may step down.
Thank you.
Okay, so our next witness is for AM Gas. Mr. Valentine?
Thank you, Your Honor. AmGas calls Mr. Bart Levine.
Hello?
Good morning. Can you hear us okay?
Yes, can you hear me?
Yes, I think we've got you loud and clear. All right, good. Raise your right hand with me. Do you swear or affirm that the testimony you will give in this case will be the truth?
I do.
Okay. Please go ahead and state and spell your name for us.
My name is Barton Levin, BARTON LEV as in Victor, IN.
All right, so it's pronounced Levin.
However you want to pronounce it, I answered anything.
I want to get it right. I have a name people don't always get right, so I try to be sensitive to that.
That's fine.
Okay, Mr. Valentine, you may introduce your witness.
Thank you, Your Honor. Mr. Levin, what is your position right now with AM Gas?
AM Gas was recently purchased by United Energy Trading. I am currently a consultant at United Energy Trading. Prior to the purchase, I, for almost 30 years, was president of AM Gas Transfer.
That was my next question. I want to ask you, I should ask, Your Honor, should I go ahead with my direct live now, or should I do that after Your Honor has asked her questions?
I think let's just treat this as a regular direct, and if there's, that issue that we talked about earlier today and the questions that you have related to the settlement testimony, I think you should just go ahead and do that now. And then we'll do cross, and then I have questions, and then we'll do redirect. So I don't know if we'll get this done before lunch, but we will get it today.
Very good. I don't have too many questions. I want to ask you some questions about Black Hill's critique of your testimony. If we could call up hearing exhibit 118 and go to page 33. Okay, and starting there at line 7, Mr. Harrington critiques AM Gas's role in this case. And I'd like you to explain why you think AM Gas does represent its customers in this case.
My understanding of the role of an agent based on common law is that the agent is charged with representing the best interest of his customers or clients as he sees them with respect to the issues involved.
Okay, do you believe that it is in your customers' best interests to not consolidate the GCA areas?
Yes.
And why is that?
I think that there's more volatility involved in that if they're consolidated. Most of our customers are all of our customers are in the Western Slope areas, the 2 Western Slope areas. And there, we have some ability to mitigate that volatility through storage. We don't want to see that storage area spread out over the entire company's Colorado facilities. We just think that from a standpoint, also our customers have paid for this storage, as have Black Hill's customers over a long period of time. And just doesn't seem appropriate to just kind of take that investment away and allow other people across the state to use it if it's possible to keep it the way it is.
Okay, and as the agent for your customers, when you've participated in many of these cases, is that right?
Yes.
And you've always advocated on behalf of your customers' best interests, right?
Yes.
Have you ever recommended that a customer return to sales service?
Yes.
Okay. That is all I have, Your Honor.
All right, cross-examination, Mr. Ocean or Albright.
Thank you, Your Honor. Hello, Mr. Levin. My name is James Albright. I don't think I've ever met you. Well, I'm still not meeting you face to face, I guess electronically, but I represent the company in this proceeding. So thanks for providing me.
It's a new world out there.
Yes. Now, as far as, now you're not an attorney, are you, Mr. Levin?
I am not an attorney.
Okay, yeah, so you mentioned common law and your agency representation, if you will, of the interests of end-use customers on Black Hills Colorado Gas's system. You recall that?
I do recall that.
Now, you would agree, would you not, that AM Gas is a party to certain agency agreements provided for in the company's tariff, in which the end-use customers who are electing to receive gas transportation have signed, as well as AM Gas. Is that true?
Yes.
And are you contending that under those agency agreements, that AM Gas has been authorized by its end-use customers to represent their interests in regulatory proceedings before this commission?
I'm not sure I understand the question.
I'm just trying to clarify where you believe your authority to represent the company's gas transportation end-use customers comes from. So you mentioned common law agency, and I just want to make sure that you're not referring to the actual agency agreements that you have signed with the company's gas transportation end-use customers pursuant to the tariff.
Let me try to answer your question this way. There's nothing in the agency agreement that prohibits me from attempting to serve my customers in these regulatory proceedings.
Okay, and your service to those customers is as a gas supplier, correct? You are selling gas to these gas transportation end-use customers. Is that right?
I am selling gas and I'm delivering it across Rocky Mountain Natural Gas, the upstream pipeline, and also attempting to ensure that the delivery across Black Hills distribution system is done in a manner that's best for my customers.
Okay, now, so when you say delivered across Black Hills Colorado Gas's system, would you agree that AM Gas is not a direct gas transportation customer of Black Hills?
Yes.
And would you agree that AM Gas is not a sales customer of Black Hills Colorado Gas?
I would agree.
And so your interest in this proceeding is really as a seller of gas to the end-use customers that receive transportation service from the company.
I think that the transportation from the wells to the customers' meters is an integrated system. My customers, I try and do the best for my customers, both in terms of acquiring the gas and also managing the transportation across the entire system. To that extent, I've been involved in just about every Black Hills rate case and those of its predecessor companies since the mid-1990s.
So, but that's the upstream transportation you're referring to. AM Gas enters into arrangements with Rocky Mountain Natural Gas, as well as maybe some gathering companies, maybe Colorado Interstate Gas, other upstream companies to ensure that the gas supplies makes it to Black Hills Colorado Gas's distribution system. Is that what you're referring to?
No, I guess I'm saying that it's an integrated process, both the purchase of the gas and the delivery. And frankly, Rocky Mountain Natural Gas and Black Hills Colorado Gas are operationally quite interconnected. For example, Black Hills Colorado Gas controls all of the on-system pipeline capacity on Rocky Mountain Natural Gas, and some of that is allocated to AM Gas customers. Some of it is retained for Black Hills Colorado Gas customers. I think it's important to understand that there are issues that are in the Black Hills, Colorado gas tariff that are important to AM gas customers.
Okay, but with respect to that upstream capacity, AM gas is, manages that capacity on behalf of the company's end-use customers, isn't that right? Through a
Yes,
limited term partial assignment?
yes,
Yes, so both Black Hills Colorado Gas and AM Gas manage capacity on Rocky Mountain Natural Gas Company, isn't that right?
yes.
Now, as far as your relationship with those end-use customers, back to that, would you agree that end-use customers buy gas from AM Gas transfer through an arm's length transaction?
Yes,
And those arm's length transactions are reflected in gas agreements. Now, are they NASB compliant, North American Energy Standards Board type contracts? Or, I mean, you don't have to, I don't want to get into any confidential information, but I just want to know generally what type of contracts those are that you enter into with end-use customers. You don't have to disclose any confidences in answering that.
Your Honor, I'm going to object to this line of questioning. We're getting a little far afield of the direct.
Overall,
So the question, Mr. Levin, was what type of contracts do you enter into directly with the company's gas transportation end-use customers? Just so that's a relationship that the company's not involved in, correct?
that's correct. We do not use the NAESB standard contract. We have contracts that we've developed ourselves.
And under those contracts, has the end-use customer authorized AM Gas Transfer to represent its interests in commission regulatory proceedings?
I would have to look at the contracts. I'm not prepared to answer that question right at the moment.
But your interest in those contracts is to sell gas to those end-use customers at a price where AM Gas can hopefully make a profit. Is that right?
My interest in those contracts certainly is to sell the gas in a manner in which I can make a profit. It's also to sell the gas on a basis that is beneficial to the customers themselves.
And that benefit, if you will, to the customers is to pay overall less for the gas delivered to their end-use facilities than they otherwise would under the company's gas sales service. Isn't that right?
In some cases, that is correct. Other cases, there are other services we provide that may mitigate that or dilute that particular aspect.
Okay, so in addition, end-use customers have additional service options that AM Gas can provide that the company can't provide?
AM Gas may provide additional benefits that the company does not provide.
Okay, and those benefits are not related to the overall cost that the end user bears when buying gas from AM Gas Transfer?
I don't understand the question.
Incremental service other than sales service is my question.
To cut to the chase, for example, I hate to do this, but I don't want to drag this out. Some customers, for example, have interest in having a fixed price for their gas or their gas service over a period of time that matches their budget year. And AM Gas can, in some cases, does provide that service that the company does not.
Okay. Now, with respect to let me just see if I can shorten this a little bit. So you indicated that AM Gas does not receive gas sales service from the company, nor does AM Gas receive directly gas transportation service. Isn't that right?
Yes,
But you do, as agent for the end-use customers that you have an agreement with, you do manage the company's gas transportation service on their behalf, right?
I think it does. What? I don't understand the question.
The question is, under the company's tariff, AM Gas Transport is an agent on behalf of the end-use customers that has certain responsibilities. And I'm just getting into what those responsibilities are.
Yes, we do have our parties to the company's agency agreement.
Okay, and those responsibilities include nominating gas deliveries to the company's system for delivery to those end-use customers.
Yes.
And those responsibilities also include managing transportation imbalances on behalf of those end-use customers.
I don't believe there are any imbalances on the distribution system.
So there's no imbalances between the gas received by Black Hills Colorado Gas and the gas delivered to the end-use customers that you represent? They're always in balance?
I believe that is correct. I believe the imbalances are handled on the upstream pipeline.
Okay, are those through operational balancing agreements? Are you aware of the relationship there?
We do, on the western slope, there is no balancing on the Black Hills distribution system that I'm aware of. The balancing all takes place on the upstream pipeline.
And you manage the imbalances on the upstream pipelines, correct?
I'm sorry?
And you manage the transportation imbalances on the upstream pipeline, correct?
Yes.
Okay. Now, does any of the end-use customers that you represent do not pay the company's GCA rates, isn't that right?
Not for the gas that we provide. They may have other meters that they do where they do pay the GCA rate. Many of them do.
So, but those are sales service customers for those particular meters, right? So to the extent that you're representing end-use customers in this proceeding, none of them paid the GCA rates under the company's tariff, isn't that right?
Yes.
Okay. So I would like to, Ms. Federico, open hearing exhibit 121. And before that, maybe I can set a little foundation. You mentioned on a hearing exhibit 700, you mentioned on page 4, so let's call that up just so you can see what the reference is to. On line 6, you represent that the commission rejected the company's request to consolidate its rate areas in the company's last rate proceeding. See that?
Yes.
Now, does this question refer to the gas cost adjustment consolidation or to the base rate area consolidation that was discussed but not really proposed by the company in this case?
I honestly don't recall at the moment.
Okay. Are you aware that the company had a rate case, its last rate case proceeding was in 2021?
I believe so, yes.
And in that case, the company did not propose to consolidate either base rate areas or GCA rate areas, correct?
And if that is correct, then I misspoke.
Okay, you misspoke in this line. So this one, when the commission rejected the company's request, you're referring to proceeding 23AL-0231G, isn't that right? That was the preceding case before the 2021 rate case.
Okay,
You agree?
yes,
And were you involved in that? Was AM Gas a party to that case?
I believe that I was, but again, I cannot really recall.
Okay. Now I would look at hearing exhibit 126. No, I'm sorry. That's not the one. 121. And if you would turn to paragraph 2. Oh, do you recognize this document? Let's go to the bottom and see who signed this. So this is signed by Mr. Valentine on behalf of AM Gas Transfer Company. And the caption on this, the title of this pleading is motion to intervene. Is it motion or it's a petition to intervene? So this is the company's or AM Gas Transfer's intervention pleading in 23AL-0231G, correct?
Yes,
And I would like to call your attention to paragraph 2. And I'll give you a few seconds to read that, and then I want to ask you a question.
okay,
And in this pleading, AM Gas Transfer claims that Black Hills Colorado Gas, Inc. is a direct competitor to AM Gas. You see that?
I don't see that in 2. Where is that?
It's the line on page 2, that the last line of paragraph 2.
Okay,
You agree that that's AM Gas's statement in that pleading?
yes,
And do you agree with that statement?
yes,
Okay, let's move to paragraph 7. And I would like you to read that paragraph to yourself, and I'll ask you a question.
okay,
And I'd like to look at that last line. You're saying that the company's case, its proposals will directly and substantially affect potentially the competitive playing field with Black Hills Gas Distribution. You see that?
all right,
Now, Black Hills Gas Distribution did not exist at this time, so that reference is really to Black Hills Colorado Gas, right?
if you say so, yes.
Okay. And so what do you mean by the competitive playing field? What does that mean with respect to that statement?
I'm trying to deliver a service that is cost effective for my customers. That involves both the cost of the gas and the cost of the transportation and delivery of the gas. Oftentimes, there are provisions made to the Black Hills Colorado Gas tariffs that do affect the cost of transportation on Rocky Mountain Natural Gas and on Black Hills Colorado Gas, and may be different for transportation customers than for Black Hills sales customers.
Your Honor, I'd move for the admission of hearing exhibit 121 at this time.
Any objection to the admission of hearing exhibit 121?
No objection, Your Honor.
Now, Mr. Levin,
Let me admit it.
I'm sorry,
Hearing exhibit 121 is admitted into evidence.
apologize, Your Honor. Now, Mr. Levin, are you starting to recall that proceeding 19AL0075G?
You know, you're asking me to recall something that happened 4 years ago. I'll do the best I can, but
Okay.
you know, I'm really not prepared to speak in depth to a proceeding that was handled 4 years ago and is just coming up today.
Okay, well, would you recall, or perhaps I'll help pique your recollection, that the company in that proceeding proposed to consolidate not only its base rate areas, but several GCA rate areas as well.
I honestly don't remember the details of that case.
And you don't recall that AM Gas Transfer under your signature entered into a stipulation in which it agreed that the company could consolidate its GCA areas, moving from 7 separate GCA areas to 4, the existing 4 GCA areas that exist today?
I vaguely remember that, but if my signature is on there, or if my attorney's signature on there, then I must have agreed to it.
Okay. Let's move to the issues at hand, which really is the company's proposal to, number one, collapse the Western Slope GCA area and the Western Slope with storage GCA areas into one GCA area. Now, there's a second issue under the settlement agreement that AM Gas also opposes, and that's the Western-Eastern restructuring. Isn't that true?
Yes.
Now, the Western-Eastern restructuring would not take place until sometime in 2015, correct?
That is my understanding.
But the
Hang on, objection. I just want the record to be clear. Did you say 2015?
I'm sorry, 2025. My decades are merging together as well.
Mine too, Mr. Albright.
Yeah, so the settlement agreement provides that the collapse of the Western GCA area, the Western Slope GCA area, and the Western Slope of storage GCA areas will occur with the company's next GCA file. Do you agree with that under the settlement?
Yes.
So you're opposed to that, but my question goes, I'm trying to differentiate between your opposition to that particular consolidation and the future consolidation in 2025 that would result in a GCA structure that has 2 GCA areas, one essentially west of the Continental Divide and the other essentially east of the Continental Divide.
Okay, what's the question?
The question is, you're opposed to that latter restructuring as well as the initial restructuring.
Yes.
But if the first one goes into place, the issue with respect to the Western GCA and Western Slope GCA being consolidated is really just adding one more element in the future, which would be to incorporate the Southwest GCA area into that Western GCA area. Is that your understanding?
Is there a question there?
Yeah, I'm just testing your understanding of what the difference is between the initial consolidation and that future 2025 GCA consolidation.
I'm going to try and answer this globally. I hope my attorney doesn't object too strongly, but there are a couple issues here. Number one is we don't understand why the timing of the consolidation of the Western Slope and Western Slope with storage areas should be different than the later consolidation, other than the fact that the company feels like it can do it. As far as the overall consolidation goes, there are 2 issues there. One has to do with the concept of cost causation. We think that to the best the company can, its rates ought to be cost-based, and to the extent that there are different costs in these different GCA areas with respect to both upstream charges, gas costs, and storage costs, that those should be kept separate and not consolidated.
Okay, and I didn't hear an objection from your attorney, but I was wondering, Mr. Levin, you turned your head. Were you reading from notes when you just testified right there?
I'm reading from the settlement agreement itself,
Okay,
which is
All
what
right,
here?
I think that I failed to give you an advisement when you began testifying, and I'm gonna go ahead and give that to you now. You really cannot look at any documents unless you are directed by a party, or by counsel or by me to do so, and you're not allowed to receive any assistance with your testimony. Do you understand those?
My apologies, Your Honor. I was reading hearing exhibit 117, which I have on another screen. I will now remove hearing exhibit 117 from that screen.
And if you need to look at a document to aid you in your testimony, you can certainly let the attorney or let me know, but you have to be directed to look at a document before you may do so to assist you with your testimony. So, Mr. Albright, you may continue.
okay, Mr. Levin, could you turn to page 5 of hearing exhibit 700, which is your answer testimony in this proceeding? The question on the top of page 5 is, what are GCA rates? You see that?
Yes.
And your response is that the GCA is a rate rider that collects and tracks natural gas commodity purchases and upstream costs incurred to transport gas to serve the company's retail customers. You see that?
No, can you give me line numbers, please?
2 and 3.
Okay. All right, what's the question?
Okay, so with respect to this transport gas to serve the company's retail customers, that transportation you're referring to is transportation on the upstream system, correct? The upstream,
Yes.
the upstream pipeline necessary to deliver the gas to Black Hills Colorado Gas's system.
Yes, and this was a direct quote from the Christofferson direct testimony.
Okay, well, it's not, there's no quotation mark, so I assumed it was your testimony, but
if you look at line 4, parentheses.
okay, I just didn't want there to be a misunderstanding that those upstream costs are costs on the company's system. It's upstream of the company's system.
Okay.
And would you agree that all of those upstream service costs are recovered through the company through its GCA?
Yes.
And again, the end-use gas transportation customers that you represent on the company's system do not pay that rate, correct?
They, in a sense, I don't understand the question.
I already asked you this question. I was just confirming based on this description of GCA rates that the end-use customers of the company receiving gas transportation service that you sell gas to do not pay these GCA rates.
They pay components of the GCA rate in a different basis than the sales customers pay it.
Okay, what component is that?
The upstream pipeline charges.
Okay, and are you referring to GT1 rate component under the GCA, or are you referring to something else?
I don't know what you mean by GT1.
Okay, well, if the company, you're saying that the company collects a component of the GCA from the end-use transportation customers that you sell gas to?
No, the company does not.
Okay, so let me move on. I want to get an understanding and perhaps enlighten Your Honor as to the nature of the gas transportation business. And really, it's just a matter of you explaining your operations. Now, how is How is, well, let me move on. Let's get page 16, since we're on this page 700. Try to narrow this scope so we can all go to lunch. So page 16, I'm sorry. It's page 15. I had my notes wrong. So on the top there, this is, and you can scroll to, page 14. This is under the question, do you have recommendations as to how the issues should be resolved? Okay. And you object to, number one, you object to the move towards a statewide GCA. But in number 2 on page 15, Western Slope with storage rates, you recommend the company should be treated exactly the same as all other GCA. This rate area should be treated exactly the same as all other GCA cost adjustments. You see that?
Yes.
Now, what do you mean by treated exactly the same?
The company had proposed to gradually change to a statewide GCA area for all other consolidations other than the 2 Western Slope areas. Those were to be combined effectively immediately. The company provided no justification for doing that other than that it could. And I was saying here that whatever came out of this case ought to be applied to both the consolidation of the 2 Western Slope GCA areas on the same basis as any other GCA area consolidation.
Okay, well, my focus on this question is treated exactly the same. The company disagrees that currently the Western Slope with storage GCA customers are treated exactly the same as any other GCA customer on the system. Are you familiar with that contention by the company?
No.
Well, is there any other area on Black Hills system that you're aware of where storage costs from an upstream pipeline are specifically recovered from one group of customers within a GCA area?
I am not aware of, I'm not that familiar with the company's other GCA areas.
Okay, but you also, and I believe you state in your motion to intervene in this case that you have customers on XL Energy's system in Colorado as well as Black Hills Colorado Gas, correct?
Yes.
And are you familiar with how storage service costs on XL Energy are treated with respect to GCA customers?
No.
Are you aware that XL Energy in Colorado has only one statewide GCA?
I'm sorry, say that again, please.
That I'll call them Public Service Company in Colorado, just to be specific to who I'm referring to, since XL Energy is, I think it's 7 states. But Public Service Company in Colorado provides gas transportation service throughout its system in Colorado, correct?
I'm sorry. Please say it again.
Public Service Company of Colorado provides gas transportation service throughout its system in the state of Colorado.
Yes.
And AM Gas Transfer does business on Public Services system, correct?
Yes.
And just like Black Hills, Colorado, you are competing against Public Service Company of Colorado's GCA rates when you sell gas to customers served by Public Service Company of Colorado, correct?
Yes.
And my question to you is, are you familiar with how Public Service Company treats its upstream storage costs with respect to its GCA?
No.
So you're not aware whether or not there's a carve out similar to the Rocky Mountain storage costs in the Western Slope with storage GCA?
No.
Okay. So
Mr. Albright?
Yes.
How much more do you have? We're already at the lunch hour.
I am looking at 10 minutes.
I think we should just go ahead and break for lunch.
Okay.
I want to make sure we can get a full hour of time for lunch. So it is, it's 12:01 right now. We will be in recess for lunch until 1 o'clock. Back at 1. There we go. Okay, so we were just muted on our Zoom, so I'll just state again that we're gonna be back on the record. And where we left off, the company was in the middle of, nearing the end of its cross-examination of Mr. Levin. And I see we've got Mr. Levin. If somebody could please, close the hearing room door so we don't get any additional background noise. And then, Mr. Albright, you can continue when you're ready, and I'll just remind you, Mr. Levin, you're still under oath.
Good afternoon, Mr. Levin.
Good afternoon.
Just to follow up on that last bit of questioning, I just wanted to confirm whether or not you were aware that Public Service Company of Colorado has a single statewide GCA in Colorado.
I believe that is correct.
Okay. Now, gas utilities, Colorado gas utilities anyway, do not make a profit on the sale of the gas commodity to their sales customers. Would you agree with that?
That is my understanding.
The GCA is a dollar for dollar pass through of the utilities costs to bring supplies to the system, including the upstream costs, correct?
That is my understanding, although there are some timing differences.
Okay. Now, I just want to compare or maybe contrast your role and responsibility as a gas marketer on the company's system versus the company's role and responsibilities with respect to service to the customers. And you would agree, wouldn't you, that the utility and the gas marketers have different responsibilities with respect to supplying gas to customers connected?
Yes.
To each? And now the gas marketers, such as AM Gas, you have responsibilities to act within the parameters, the various parameters set forth in the tariff. Would you agree with that?
That question is a little broad for me. I'm sorry.
Okay, well, as far as how you are restricted, how AM Gas is restricted in how it provides sales, we'll call it sales service to the company's end use customers, you must comply with all of the terms and conditions of the tariff, correct?
Yes.
And so that includes having end users submit requests for transportation service.
Yes.
That would include ensuring that the company or that the end use customers sign gas transportation service agreements.
Yes.
And that would include end use customers who you act as agent for to sign the agency agreements designating you as agent, right?
Yes.
And that would also include submitting nominations in accordance with the precise nomination schedule provided under the contract. That would include submitting nominations in accordance with the precise nomination scheduling procedures under the company's tariff.
We do not submit nominations to Black Hills Colorado Gas.
You don't? You do that on the Rocky system?
Yes.
And that's pursuant to the assignment of Rocky capacity that's provided for under the company's tariff?
We do that pursuant to the Rocky tariff.
Okay. Now, let's compare that to the utility. The utility, on the other hand, must ensure that it has sufficient gas supplies to operate the system and to meet the demand on the system, the customer demand. Would you agree with that?
That is the objective.
And to do this, the utility must use its gas supply portfolio, including its upstream pipeline capacity that it's contracted for, to make sure they can operate the system prudently and to ensure that it meets its system requirements. Would you agree with that?
I'm not sure why you're asking me this. These are questions that should be directed to your own people.
Okay, but would you agree that that's the company's responsibility and not your responsibility as a gas marketer?
I kind of feel like you're asking me gotcha questions because you're asking me questions that I'm really not concerned with. I'm not concerned with how the company gets gas supply.
Okay, but you are concerned about how the GCA rates are calculated. That you're
Yeah.
opposing the company's proposal under the settlement, right?
Yes.
And so my objective is to determine that your responsibilities with respect to serving customers is much different than the company's responsibility in serving customers. Isn't
I
that
would
fair?
disagree. I would disagree with that.
You would disagree if that's what I'm trying to do, or you would disagree that there's a difference?
I would disagree with that there is a difference.
Okay, so I want to answer the question. Is it the utility as compared to the gas marketer has the responsibility to ensure that it has sufficient gas supplies to operate the system and to meet the demand on the system? You already agreed to that.
Okay.
Okay, and then to do this, the utility must use its gas supply portfolio, including the services it subscribes on the upstream pipelines, to meet these requirements, to satisfy this responsibility as a utility. Would you agree with that?
That seems reasonable.
I'm gonna object, Your Honor. Mr. Levin is not operate the utility, and he's a gas marketer. It's not his responsibility, and he's not familiar with how the company goes about its business. There's no foundation for these questions.
Overruled. Overruled means you have to answer the question. Mr. Albright, why don't you repeat the question?
I will. So in order for Black Hills, Colorado Gas, as well as public service companies, as well as other gas utilities in Colorado that provide for gas transportation, in order for them to meet their obligation to ensure sufficient gas gets on the system to serve their customers, as well as to maintain prudent operations, doesn't the company rely on and use its gas supply portfolio, as well as its upstream capacity on interstate pipelines and other upstream pipelines, to provide that, or to satisfy that responsibility? That's my question. You acknowledge that is?
I believe that is correct.
All right. And that you as a gas marketer don't have those same responsibilities. Would you agree with that?
No.
You would not agree with that?
That's correct. I would not agree.
So tell me to what extent you disagree.
I believe that my responsibilities with respect to my customers are exactly the same as your responsibilities with respect to your customers. To use all of the resources available to me, including my gas purchase portfolio, if that's the term you used, to make sure that my customers have all the gas they need with the same reliability as if they were your customers.
But I was talking about the operations of the system. You have no role or responsibility with respect to the operation of the gas distribution system, do you?
No.
And if you
But that's not the question you asked.
Okay, well, I asked if it was the company's responsibility. You said yes, and I asked if the company uses gas supply portfolio and upstream service cost per portfolio to satisfy that obligation, and you said yes. But then you disagreed that you have any different obligation. Is that fair?
Yes.
And so what happens if you fail to deliver sufficient gas onto the system to serve the Black Hills, Colorado end-use customers?
What happens if I do that?
Correct.
In the short term, Rocky would supply that gas.
Okay. And
in the longer term, I would have some serious problems. Okay. And what's the repercussions of those serious problems from your standpoint? I would think that if I had any kind of a pattern of not supplying an appropriate quantity of gas for my customers, Rocky would shut me down. Okay.
And who would be responsible for any costs or any gas shortages that occur as a result of your failure to deliver that gas?
I would be.
You would be, and not the end user?
I think that Rocky would come after me first and before going to the end user.
And are you familiar with the fact that if payment is not received from an end user's agent, that the end user is ultimately responsible? Are you familiar with that provision in the tariff?
No, let me say that I have not looked at the tariff in a long enough period of time to be able to speak appropriately to that question.
Okay. But if there's a gas shortage under Black Hills, Colorado Gas's operations, there's serious repercussions to the end use customers. Isn't that true?
I don't understand the question.
If the gas distribution system is under pressure, there will be outages. Are you familiar with that terminology?
Yes.
And gas pressure must be maintained in order to ensure delivery to customers. Would you agree with that?
Yes.
And if gas doesn't make it on the system, the result is that there's lower pressures and a risk of customers not getting gas supply and their pilots going out and their operations failing because they don't have a sufficient supply of gas. Would you agree with that?
Yes.
And your responsibility, if you fail to deliver sufficient gas to the company, is simply contractual and penalties and maybe lawsuits. But as far as system outages, you have no responsibility over system outages, right?
I do not have responsibility for system outages on the Black Hills system.
But Black Hills does. Would you agree with that?
Yes.
Now let's turn to hearing exhibit 700, page 8. Hearing exhibit 700 is your answer testimony, Mr. Levin. Now, lines 1 through 4, you're referring to the 2013, you call it the Rocky rate case, but just for clarification, that was more than just a rate case, right? That was a restructuring case. Would you agree with that?
There were certain elements of restructuring, yes.
And in that case, Rocky, and we're referring to Rocky Mountain Natural Gas, Rocky essentially exited the merchant business. Would you agree with that?
Yes.
So they stopped being a buyer and seller of gas and proposed to become a transportation only pipeline. Would you agree with that?
Yes.
Okay. Now, what you say in this statement is that Rocky agreed to only charge the cost of the storage facility, and this is the Wolf Creek storage facility, correct?
Yes.
To those customers that were in areas that could receive gas from storage, that is, those customers that benefit from the service. See that?
I see it.
Now, what are the benefits of storage when it comes to, well, let's just say AM gas? What are the benefits of storage to the services that you provide in, on the western slope of the system?
I would say that the principal benefit is that it provides for increased reliability.
And that's an operational benefit, correct?
Yes.
But it also, does it not provide some price benefits, some gas pricing benefits?
It can.
And those gas pricing benefits relates to the fact that you can inject gas into storage when prices are generally low, say in the summer months or off non-winter months, and then use that gas during the winter months when gas prices are generally higher. Would you agree with that?
Since 2013, In most years, that is correct. However, there have been years in which that did not work out. We actually paid more to put gas into storage than we received when taking it out.
Okay, but generally that's one of the benefits of storage, right?
Yes.
It's maybe a hedging tool. Would you agree with it being a hedging tool?
It can be.
It provides arbitrage opportunities. Would you agree with that?
No, because I don't understand what you mean by arbitrage.
Arbitrage meaning you can buy gas at a low price and sell it at a high price later. Simply just buying and selling gas commodity.
Yes.
Now, are you aware how the company calculates the cost of the gas commodity exclusive of storage on Rocky for its Western Slope customers?
No.
Are you familiar with Mr. Christopherson's testimony where he explains that the commodity costs are pooled throughout the Western Slope and Western Slope with GCA storage areas?
I've read Mr. Christopherson's testimony.
Okay, well, would you agree, subject to check, that the company does not allocate gas supply prices, gas supply costs, I mean, separately from the Western Slope with storage from the Western Slope without storage GCA areas?
Yes.
That they all pay, they all share ratably, if you will, in those gas commodity costs. Right?
Yes.
Okay. So if one of the benefits of storage is the pricing benefits, then the Western Slope customers that don't have the storage adder are receiving the benefit of storage. Would you agree with that?
Say again, please.
If all the Western Slope and Western Slope with storage GCA customers are paying this essentially the same commodity cost under the GCA, then they are all receiving the pricing benefit that results from the use of storage service.
I believe that is correct.
And if all the customers were receiving a benefit, but only the Western Slope with storage customers are paying for the storage costs, doesn't that violate principles of cost causation?
I think it's the way the company is charging for the commodity itself that violates the principles of cost causation.
Okay, but my question is it fair in your mind that only a select group of customers, the ones that are downstream of the Wolf Creek storage facility, are paying for that storage cost, but they're not receiving 100% of the benefit of that storage service? Does that sound fair to you?
I don't answer questions about fairness.
You will do your best to answer the questions that are asked of you here today, unless there's an objection that I sustain. And I feel like there've been a couple of instances where you've tried not to answer the questions. So let's stop that now.
No, I just think that fairness is one of those weasel words that used for a lot of different purposes. So that's why I don't like fairness. I will say that there are different gas supply pools on the Western Slope system, in addition to the Wolf Creek storage area, that tend to create different gas costs in different areas that everybody pays for. For example, the south end of the system has a much from Montrose to Telluride has I believe, a higher cost of gas than does the rest of the system, the eastern end of the system, and yet all customers pay the same rate for that, pay the same gas commodity cost.
And do those customers also pay the upstream pipeline costs?
Which customers pay upstream pipeline cost?
The customers on the Black Hills, Colorado system,
Yes, they do pay upstream pipeline cost.
but only the storage costs under the no notice service contract is directly allocated to a subgroup of customers in the Western Slope area, right?
Yes.
Okay. Now, back to your AM Gas's operations, as stated earlier. How is, let's see, you stated that AM Gas tries to turn a profit. You obviously have been very successful. Commendations to you. I know it's a tough business with slim margins, so you've done very well for yourself, Mr. Levin. But my question is, how will AM Gas's ability to turn a profit change when Black Hills, Colorado Gas, or if and when Black Hills, Colorado Gas collapses the Western Slope with storage GCA into one GCA with the rest of the Western Slope GCA customers? What will change?
I've not done an extensive analysis of this, but my gut tells me that our margins will increase slightly.
Your margin will increase slightly if the collapse is done.
Yes.
Okay, and well, how will this change if and when Black Hills, Colorado Gas moves to the Western Eastern GCA structure? Do you know?
No, I have not really examined that.
Okay, I have no further questions, Mr. Levin. Thank you very much.
Mr. Levin, I've got some questions for you. So we might want to pull, why don't we go ahead and pull up your exhibit 117 and go to page 26. So what I'd like, I've heard from other parties who have represented in filings what AM Gas's position is on the settlement agreement, but I actually really haven't seen much from AM Gas directly. So what I've had done is pull up pages 26 to 27 of hearing exhibit 117. And if we could just scroll down just a little bit on the screen. So what's on the screen here is section 3B as in boy 5. And it carries over onto the next page. And it would be a total of, I think, paragraphs 70 through 71. And then the two unnumbered paragraphs that follow are all part of section 3B5 of the settlement agreement. And I'll say the other parties have represented that AM Gas only opposes those paragraphs and provisions in the settlement agreement, the ones that I just went over in detail. So I'm wondering if you can confirm that for me, that those are the only provisions that AM Gas opposes in the settlement agreement.
I believe that is correct.
And is it also correct then that AM Gas does not object to or oppose any other provision in the settlement agreement?
I think that's correct. I'm sorry. Our focus has been on the GCA consolidation, both in terms of the two Western Slope areas and the remainder of the state, the Western Eastern or whatever, however it is. So yes, I think our objection is confined to the GCA area consolidation.
Okay, well, I'm going to tell you right now that as of the time of the hearing, that's something that you should know pretty firmly what AM Gas objects to. So I am going to take your testimony at face value and as a representation that AM Gas does not object to any other provision in the settlement agreement outside of section 3B5.
I'm having trouble correlating section 3D5 with section 70. What, I'm having trouble following you.
What are you not following? You've already answered my questions.
I apologize. I wasn't aware there was a question there.
There wasn't. You've answered my question. So what is it
Okay.
that you're not following?
When you talk about section 3D5, I don't know what section 3D5 is.
Okay, so I guess we're gonna need to break that down for you. We've got hearing exhibit 117 on the screen. If you can see at the bottom of page 26, there is sort of a header that says number 5 GCA consolidation. You see that?
Oh, yes, I see that. I'm sorry. I was hearing 3D5, 3 dog 5, and didn't understand where we were going here.
Well, we're gonna break it down for you. And it's not a D as in dog, it's a B as in boy. And I can understand a little bit of confusion there because you're not gonna be able to see the full Roman numeral breakdown heading. But let's just be clear, the paragraphs that AM Gas objects to in the settlement agreement are found on page 26, paragraph 70, and then going on to page 27, paragraph 71, and then also the 2 unnumbered paragraphs that follow paragraph 71. Is that correct?
I believe that is correct.
Okay, and those are the only paragraphs of the settlement agreement that AM Gas objects to, correct?
Unless my mind is slipping here and my attorney gives me something that I talk about on redirect, I believe that's correct.
It's not a trick question. It really isn't. I just need to know what you object to and what you don't object to.
I'm having trouble switching gears here from getting beat up by the company to hearing from an impartial questioner here.
Okay, well, I think at this point I have enough in the record that I understand what you object to and what you don't object to. So we can move on. Why don't we pull up hearing exhibit 118 and go to page 33. And you were asked a number of questions, I think, on cross-examination, and I do apologize, you might have covered some of this already, but I might just ask again so that I can get a clearer picture and understanding in the record. Hearing exhibit 118 is a testimony that Mr. Harrington provided, and there was a discussion, I think, on your cross-examination or your direct, possibly, about some of the things that Mr. Harrington said about AM Gas interests in this proceeding and role with the company and the company's end-use customers. So on page 33, do we have that up there? Okay. So what I want to focus on are lines 13 to 21, and then carrying over on page 34, 1 to 10. And you can just take a moment to read that to yourself. If you have a paper copy of that, you're welcome to refer to that. That might be easier for you. Or you can pull up an electronic copy on your computer screen. I'm just going to give you a moment to read those lines.
All right,
and then
stand
let me know
by.
when you're done.
All right, I'm going to look at my company copy, which has a little bigger print.
That's fine.
Okay. All right, I've read the information.
Okay. Give me just one moment. I'm trying to do the same and pull up an easier copy for me to look at my screen, but unfortunately Adobe keeps giving me problems. So, all right, got it fixed. Oh, and then it just closed. All right, so I'm gonna have to use the same thing that's on the screen here. Yeah, that I can read that. So this exhibit is already in the record, so I'm not gonna go through and reread every line that's in here. But there's a lot of statements starting on line 13 of page 33, carrying over to line 10 on page 34 that the company makes about AM gas. And I wanna know if you disagree with any of that.
As I stated before, I believe that our responsibility is to represent our customers in matters both with respect to Rocky Mountain Natural Gas and Black Hills Colorado Gas. Over the years, issues have come up in the Black Hills Colorado Gas tariff filings that I felt were adverse to our customers, and we have intervened in those cases and attempted to mitigate some of those changes and have had some success.
Okay, so I'm not sure what about your testimony just now would indicate whether you agree or disagree with the testimony that I just pointed out. So let me re-ask the question. Is there anything specific from lines 13 to 21 on page 33 carrying over to page 34, lines 1 through 10 in hearing exhibit 118 that you factually disagree with?
I think that this was restrictive. I believe that my responsibilities as an agent for these customers is broader than what's portrayed here.
Well, I guess we'll just have to go through every line. All right, so let's start on line 13. The company offers its customers the ability to procure their natural gas needs from independent, non-regulated gas suppliers or marketers, and to have those gas supplies delivered to their end-use facilities pursuant to its transportation tariffs. Agree or disagree with that?
Agree.
Next sentence, starting on line 16. Importantly, these customers who elect to take transportation service from the company do not pay the GCA rate. Agree or disagree?
I agree with respect to the gas they get from AM Gas. Some of our customers are also sales customers of the utility.
Okay. Moving on, still on line 17. Rather, they contract to buy gas from a gas marketer like AM Gas. Agree or disagree?
Agree.
Moving on, still now on line 18, AM Gas then sells that gas to these customers at non-regulated prices. Agree or disagree?
Agree.
Still on line 18, while the company does not profit on the sale of the natural gas commodity to the customers, AM Gas does. Agree or disagree?
That is our objective, is to make a profit on the gas sale.
So I'm going to take that as you agree.
Yeah.
All right, now I'm still on line 20. To solicit customers away from Black Hills BHCG gas sales service, AM Gas must provide gas supplies at prices that compete against the company's GCA rates. Do you agree or disagree with that?
I don't think that that is true in all cases.
But it's true in what, half, majority, some cases?
I would say that in a majority of cases, it's true. In other cases, as I mentioned before, there are other services that we provide to customers. There are some customers that may just prefer to deal with us than the utility. I think in some cases, we have better customer service.
But
we have the ability.
I'm really just trying to focus in on whether what's in here is something you agree with or you disagree with. I'm not asking what all the things that AM Gas does and provides, to its customers, but you would agree that AM Gas AM must provide gas supplies at prices that compete against the company's GCA rates in most cases. You would agree with that?
I agree.
Okay. All right, on line 21, we're still on line 21, and I'm just gonna ask to see if we can get the part of the next page up showing. All right, so starting on line 21, thus any changes to the company's GCA will have an impact on AM Gas's ability to compete for BHCG customers. Do you agree with that?
I can't answer that question. I don't, the company's GCA has changed many times over the years. You know, what impact that's had is not clear.
So if you're not sure and you don't know if the company's changes to its GCA would impact AM Gas ability to compete for Black Hills customers, then what is the impact on AM Gas, all the GCA consolidation that's being proposed in the settlement agreement?
I think that it provides a greater degree of uncertainty with respect to what gas costs the company will be charging to their customers that are in the same area, that are the alternative to us. I just think there's greater volatility, and it's something that it's not clear to me what the impact of that might be.
So what is AM Gas interest in whether the company consolidates those GCA areas as proposed in the settlement agreement? What is AM Gas interest in that?
I think
Sorry, did you say something?
I think we understand the situation the way it is now. We're concerned twofold. Number one, that it creates a greater level of uncertainty that we prefer not to deal with. Also, we see this as a stepping stone to a statewide GCA rate, and that's going to create a bunch of different cost structures on various areas of the company's system, which could, to the extent that we do compete on a price basis, might impact us adversely. And of course, once this thing is allowed to go in effect, if it is allowed to go in effect, there's no going back.
All right, thank you. Let's scroll down. I want to see if we can get lines 1 through 10 on page 34 onto the screen. So starting at line 5, it says, and we're still, just for the record, on hearing exhibit 118, AM Gas's role is very limited. Do you agree or disagree with that?
I disagree.
That does not surprise me. And I think you've already talked and testified about AM Gas's roles not being quite as limited as the company has described, so I'm not going to get into that. So we'll move on to the next sentence. It says, still on line 5, under the company's tariff, gas transportation service is provided for and on behalf of end-use customers on the company's system. Do you agree or disagree with that?
I agree.
On line 6, it says AM Gas signs an agency agreement as required by the company's tariff to act as an agent for end-use customers to perform certain administrative activities in the management of gas transportation services, including nominations, scheduling, imbalance management, and receiving and paying customer bills. Do you agree or disagree with that?
I disagree with that. As I stated earlier in the company's questioning of me, we don't provide transportation services on Black Hills Colorado Gas. We don't do nominations. We don't do scheduling. We don't do imbalance management. And for other than a very few customers, we don't pay customer bills, although we do receive customer bills.
So what is the primary role that AM Gas plays with the company's customers?
With Black Hills customers, we
Yes.
attempt to safeguard their interests with respect to changes that the company may choose to make through its tariff filings.
All right, so I've heard a little bit of conflicting testimony, and I'm hoping you can clarify this for me. A moment ago, we looked at a line on page 33. Let's scroll back up. Page 33, still in your exhibit 118. And at line 16 to 17, you testified, you agreed with that testimony, which says that importantly, these customers who elect to take transportation service from the company do not pay the GCA rate. You agreed with that.
Yes.
You also testified similarly, I think, either on direct or cross-examination. But I made a note that you provided some testimony stating essentially that AM Gas customers pay some portion of the GCA rate, but I never really understood what you meant by that. I don't think that was really ever teased out. So I'm hoping you can clarify, because what we have here is that generally these types of customers don't pay a GCA rate. And then
Okay.
you testify that AM Gas's customers pay some portion of a GCA rate.
I believe my response was that the customers do pay some portion of the GCA rate. They pay it on a different basis than do the Black Hills sales service customers. And what I was referring to was the fact that in the GCA rate, our upstream pipeline charges, the bulk of that, I believe, is for transportation on Rocky Mountain natural gas. So the rates the company pays to move gas across Rocky Mountain natural gas are in its GCA rates. AM Gas customers, or AM Gas also contracts with Rocky Mountain Natural Gas to move gas across that pipeline to Black Hills Colorado Gas town border stations for their final delivery to our customers. And we pay charges to Black Hills to Rocky Mountain Natural Gas that are similar to what Black Hills customers pay, although they pay it all on a per therm delivered rate. Our customers pay a certain amount of money per decatherm delivered and a certain amount of money for pipeline capacity. Black Hills Colorado Gas and its GCA rate melds those two components into one. And also there is a fuel loss component that is in the Black Hills GCA rates that we pay essentially the same thing per therm delivered.
Okay, so we were speaking a little bit more generally about AM Gas customers paying GCA rates. Now I want to focus your answer on the specific GCA rates that are that AM Gas objects to in terms of what's in the settlement agreement. And that's the consolidation of the Western Slope GCA and the Western Slope Storage GCA. So if you could answer basically the same question and let me know, do AM Gas customers pay any portion of either of those rates?
They do pay a portion of those rates. Let me think of how to answer that. Yes, the AM Gas customers who are in the with storage area pay specific charges under a provision of the Rocky Mountain Tariff for storage services. And AM Gas customers that are not in the storage area do not pay those charges.
Okay, thanks for that clarification. Let me just double check to make sure I don't have any other questions for you. That might be it. All right, I think we are good. That's all the questions that I have for you. Thank you for your patience. Mr. Valentine, any redirects?
Just briefly, Your Honor. You were asked by Mr. Albright some questions about the Piesco system, and you indicated a lack of familiarity with the Piesco GCA. Why is that?
We are not as, in terms of market share, we do not have nearly as large a market share on the Piesco system relative to other gas marketers as we do on the Black Hills system. Also, the Black Hills system comprises a larger part of our business than does the public service system. Consequently, we do not get as involved in the what goes on in the Piesco system as we do with what goes on in the Black Hills system.
And as
far as, I'm sorry, go ahead.
How many times have you intervened in a public service case?
Once in the last 25 years, or
okay.
Actually since about 2000, we've been dealing with public service.
Okay. Now, there's been, do you recall your conversation with Mr. Albright about cost-based rates and why the company's charges for natural gas being the same across its various GCA areas violates cost-based rates? Do you recall that line of questioning?
Not specifically, no. But
let me ask it this way. If the company is charging the same for the procurement of gas across its GCA, different GCA areas currently, does that violate the principles of cost-based rates?
I would think so. And the company doesn't charge the same amount across its different areas.
Okay, because that's not clear from the questioning that he asked you, right? So it's true right now, isn't it, that the company charges different amounts for gas for different GCA areas?
Yes.
Okay. I'm wondering if you can give some examples of situations where you've intervened on behalf of your customers to prevent changes to the tariff that would impact their ability to take transportation service.
Okay, believe my company's intervened in just about every Black Hills and Rocky Mountain rate case since the mid-90s. And through that period of time, there have been various changes proposed by the Black Hills and its predecessor companies that I felt would adversely affect our customers. And in those cases, we've objected and attempted to mitigate that. Perhaps the clearest example was when the company decided that it wanted to require electronic flow measurement equipment for transportation customers. Those are special electronic meter heads that are connected to phone lines and allow the company to know on a daily basis what that gas meter is consuming as opposed to a normal monthly billing cycle. Company initially proposed to do this at a cost of about $12,000 per meter, as I recall. And we felt that was, we did some research, discovered that public service was paying $400 for those devices to do the job, but was not charging the customers anything, whereas Black Hills wanted to make the customers pay the full freight as if it was a line addition. So they were not only paying the cost, but they were grossing the cost up for the tax effect of that. And we were able to get that cost from $12,000. The company agreed through the course of that proceeding to take the cost down from $12,000 to $2,000. They invented they discovered a different system that would do the job for 1/6 the cost.
Okay. Now, in this case, do you believe it's in your customers' interests to get away from the current GCA system? And I think we've heard testimony that the company currently has different GCA rates for its different GCA areas. Do you think that it's in your customers' interests to get away from that system?
No, I don't. No, I don't think it's in my customers' interest to get away from the system.
Why?
I just think that it creates more volatility. The company seems to think it will create less, but we see it as creating more. We see it as being a situation where something that happens in the eastern part of the state can impact what our customers charge. We don't think they need the additional volatility. The company wanted to do something good for its customers and find more storage.
Do you agree that right now the company has different cost metrics for its different GCA areas?
Yes.
And do you think that the shift to the eastern and western GCA areas will improve the accuracy of the rates with respect to costs to serve?
No.
Those are all the questions I have, Your Honor. Thank you.
All right, thank you, Mr. Levin. That will conclude your testimony.
Thank you.
So by my count, Mr. Levin was the last witness that the parties proposed to put on. So I want to turn to Black Hills to see if you've got any rebuttal evidence that you'd like to present.
Your Honor, I believe we do. Could we have 5 minutes to confer? And I expect any rebuttal evidence will be short.
Yes, that's fine. We'll take a few minutes and just go off the record while you are all confirmed with each other. Just signal me when you're ready to go back on the record and then we'll do that.
All right, thank you, Your Honor. Yes, Your Honor.
All right, we'll go back on record. Mr. Coshin, does Black Hills have any rebuttal evidence?
Yes, Your Honor. We'd like to call Mr. Christopherson back to the stand. We just have a couple.
So they're back.
Okay, Mr. Christopherson, please come back up to the witness stand. I'm not gonna re-swear you in. You are still under oath from your earlier testimony. Mr. Coshin, once he's settled in, you can begin when you're ready.
Can we open up hearing exhibit 120, please? Mr. Christopherson, can you tell us what hearing exhibit 120 is?
This is Black Hills, Colorado Gas tariffs that are the currently effective tariffs.
All right, and were you in the courtroom when we heard, or the hearing room, when we heard testimony from Mr. Levin a couple minutes ago about the different amounts for different GCA areas that the company charges?
I was.
And is there anywhere in these tariff sheets that can better explain what the company charges when it comes to GCA rates as compared to transportation customers?
Yes. If we were to go to tariff sheet number 13.
Page 14. Page 17, 14. Let's start with page 14. Let's go to page 17, actually, of 206. Perfect. And Mr. Christopherson, can you tell us what we see here on, first of all, who pays these rates?
This rate schedule sheet is rates that are effective for sales customers of Black Hills.
And is there a specific class of sales customers that pay these rates?
This specific tariff sheet is for small commercial customers of rate area 1.
All right, and can you describe what we see in the left-hand column of page 17?
The left-hand column describes the different various charges that are passed on to customers. The upper half under per month includes the fixed charges that are assessed to customers on a monthly basis, while the subsequent section under the per therm header are the volumetric rates that are paid on a per therm of gas usage by our sales customers.
And then can you describe the two columns on the right-hand side?
The two columns on the right-hand side are the rates that customers that are located in the specific Western Slope and Western Slope with storage GCA areas would pay.
And do you know if the per month charges that are listed there, it looks like there's 5 of them. Do transportation customers pay all of those per month charges?
They do not. They pay a portion of those per month charges.
Okay, can we turn to page 27 real quickly? And we'll kind of go back and forth. Maybe it's 28. There we go. And can you tell us what page 27 is?
Page 27 is a rate schedule for small commercial transportation customers for customers who are located in base rate area 1.
Can we just clarify that he's actually looking at page 28, not 27?
I apologize, Your Honor. Mr. Christopherson, could you tell us what are you looking at? Just kind of walk through it a little bit.
I'm looking at PDF page 28, which is the rate schedule associated with small commercial transportation customers of base rate area 1.
And do we have more than just base rate area 1 on this sheet?
There are base rate area 2 and base rate area 3, all for small commercial transportation customers.
And the Western Slope with storage and the Western Slope without storage GCA area is located in which base rate area?
Those GCA areas would be located in base rate area 1.
Perfect. So we're talking about just the first series of numbers on this page 28, correct?
That's correct.
And is there a Western Slope with storage or Western Slope without storage charge for small commercial transportation customers?
There is not.
And so, again, talking about the per month charge, before we had 5 charges, here we've got fewer. Could you tell us which ones are missing?
On the per month basis, we would be missing the low income funding, which is labeled as BHEAP, BEEP. Would also be missing the DSMCA, demand side management cost adjustment on the per month charges.
Perfect. And then the per therm charges, it appears that there are 2 different products or listings there. Is that correct?
That's correct.
And one of them is zeroed out, the GRSA?
That's correct.
Can you tell me if the large commercial transportation tariff sheets are similarly broken out?
Large commercial transportation tariff sheets would be similarly broken out and have limited line items compared to sales customers.
All right, and let's turn back to, so on the per therm basis, base rate area 1, and these would be the customers, the transportation customers that would sign up with AM Gas or other marketers.
That is accurate.
They would pay the rates under this tariff sheet.
That is accurate.
All right, so let's turn back real quick to page 17 again. Now for the small commercial, again, base rate area 1, sales customers under the per therm, you've got a much longer list of rates that are paid, correct?
Yes, there are additional charges for those sales customers that are not present for the transportation customers.
And what are some of the differences between this sheet and the one we were just looking at in terms of the per therm charge?
On this sheet, you would have the demand side management cost adjustment line item, the gas cost adjustment line item, which is inclusive of commodity, upstream, and storage cost, as well as the extraordinary gas cost recovery rider, EGCRR, that are not contained in the transportation tariffs.
Perfect. And now comparing the Western Slope and the Western Slope with storage GCA columns, what's the difference?
The one difference between those 2 columns is the line item titled storage costs. In the far right-hand column represented on this sheet, it is 0.10147. That is the additional storage cost that is allocated to the Western Slope with storage customers that is not present for the Western Slope GCA customers.
So Western Slope and Western Slope storage customers pay the exact same GCA rates except for the storage cost. Is that correct?
That is accurate. Those customers pay consistent commodity prices, upstream pipeline prices. However, the one difference is that the with storage includes a storage component, while the without storage does not include the storage component.
And just confirm, turning back to page 28, the transportation customers do not pay any GCA rate, correct?
That is accurate. You do not pay any of the GCA rates.
Nothing further, Your Honor.
Mr. Valentine, do you have cross-examination?
No, Your Honor, thank you.
I just want to ask you a clarifying question. So you just testified that transportation customers don't pay any GCA rates. Were you, I know you were here in the courtroom, but I want to make it clear in the record, you did hear Mr. Levin's testimony on this subject, yes?
I did.
And you heard him testify that his customers, which are end-use customers, pay some portion of the GCA rates, including the western slope and the western slope with storage GCA rates. How do you respond to that? How do I mesh that with your testimony?
I think there's confusion in the way that that was explained. That if we think about the GCA as being the sales component for Black Hills Colorado Gas, the GCA cost is comprised of an upstream charge. The upstream charge comes from our upstream provider, Rocky Mountain Natural Gas, in that area. My understanding of AM Gas business model is that they also contract through that same upstream supplier. So while they're contracting through the same upstream supplier in Rocky Mountain Natural Gas, they are not paying the same costs of Black Hills Colorado Gas, where Colorado Gas allocates or retains storage capacity and upstream capacity on Rocky Mountain Natural Gas. Those costs are passed on to the end use customers.
Okay, so if that provision of the settlement agreement, which would consolidate the western slope GCA and the western slope GCA with storage rates, if that's approved, are you able to anticipate what the impact would be on AM Gas's customers?
I'm not able to anticipate how it would impact AM Gas's customers. I do know how it would impact our end use sales customers.
All right, go ahead and answer it with that in mind.
Can we turn to my rebuttal testimony?
Sure, I don't know what that exhibit number is off the top of my head. Casey,
116, Your Honor.
okay, 116.
And if we go to page 26 of hearing exhibit 116, tables MJC R3 and MJC R4.
Okay, so go ahead and answer the question. Tell us how these two tables relate to your answer.
On table MJC R3, this table displays and demonstrates what the changes in rates would be if the western slope with storage and western slope without storage GCA areas were consolidated. In the second column, those are the current GCA rates of 0.95710. In the event that the western slope and western slope with storage GCA areas were consolidated, those customers would now be paying a GCA rate of 0.97383, a modest increase of 0.01673 cents per therm.
Thank you.
And if I may add, the table below demonstrates the bill impacts on an average residential customer associated with those rate changes. With the current average monthly bill increasing approximately $1.35 for customers of the previous without storage, while customers of the with storage would see a decrease in their average monthly bill of approximately $2.79.
Great, thank you. Those were the only questions that I had for you. Any redirect?
Just one quick question. Mr. Christopherson, this may have already been covered, and I think it was several times, but the distinction between the with storage and without storage, it appears the without storage monthly charge or monthly change is a reduction, correct?
The with storage would experience a reduction, correct?
And the storage facility that is incorporated in that rate, the benefits and the gas from that facility travels and can be used by customers in both of those GCA regions. Is that accurate?
That's my understanding, is that storage molecules can flow to customers in both of those GCA areas.
Thank you. Thank you, Your Honor.
All right. You may step down, Mr. Christopherson. Does the company have any other witnesses to call in rebuttal?
No, Your Honor, the company rests.
All right. So that concludes the testimony We're not necessarily done with the evidentiary portion of the hearing, because we still have to sort through the issues with staff's exhibits. And I'll note that, you know, some of these issues concern written testimony, and that written testimony is not admitted into evidence as we sit here right now. So what I'd like to do is hear from parties, starting with staff, about whether we should reconvene tomorrow or Friday to review the outstanding exhibits.
Good afternoon, Your Honor. During the lunch break, I had the opportunity to confer with Mr. Koshin, and graciously offered their help in doing so, so they'll be available tomorrow. And apart from that, I just want to spend the time tomorrow looking at each document one by one. And so frankly, I'd rather take the time to go through this than try and rush through it this afternoon. And so I guess based on those two factors, we would request that we reconvene on Friday.
Okay, I mean, I'll just say that I think that probably is the wisest choice, considering there are a huge volume of problems to get through, and I really need staff to be extremely detail oriented in your review and corrections. So I'm fine with Friday. I will pause and see if anybody's got any objections or issues or concerns with reconvening on Friday to go ahead and speak up now. Okay, I am hopeful that we could get through the exhibits if they're corrected within, you know, a modest amount of time. And therefore, I think what I would like to do is allow everybody as much time as possible to get those exhibits corrected. So rather than convening Friday morning, I'm suggesting that we reconvene in the afternoon at 2 o'clock. And it will be fully remote. We're not gonna, I just don't want parties spending their resources having to come in person. So this will be converted to a fully remote hearing just to try to sort out those exhibit issues at 2 o'clock on Friday. I'm gonna vacate tomorrow's hearing date because I don't think we need it. And then the parties can take that time to work on these exhibits. Also, what I want to do now before we recess is to go ahead and admit the hearing spreadsheet, which I believe is hearing exhibit 800. Casey, is that correct? Okay. We mentioned this earlier in the day. I'll go ahead and ask if there's any objections to the admission of the hearing exhibit 800 at this time. All right, there being no objection, hearing exhibit 800 is admitted. The parties can use that to have to go through and eliminate what exhibits are already in evidence and don't need to be messed with versus those that were not included on that spreadsheet for staff. You also, I might suggest that you go ahead and also just review the specific ones that were admitted into evidence just to ensure that there aren't confidentiality issues that need to be addressed. Like I have mentioned, I went through my legal support. My legal assistant has spent a lot of time looking at exhibits, but honestly, given the volume of problems, it's entirely possible that something got missed and it was admitted on that spreadsheet. So I want to be able to correct any issues that may exist when we reconvene on Friday. Outside of what's on that spreadsheet, the following exhibits have also been admitted into evidence via the box.com process. And those are hearing exhibit 117, Rev 1, hearing exhibit 120 and 121, and hearing exhibit 800. And then my last housekeeping matter is to remind everybody that, actually I've got two things. So statements of position are due on December 21st. So my first question is whether we need to change that deadline or if that's a deadline everybody still wants to stick with. I'll ask the company to speak on that first.
The company would propose that we accelerate that deadline with the issues in this proceeding potentially limited in scope, and when the deadline was initially established, the parties anticipated every issue in the rate case would be contested, and so we're much further down the line rather than the, I believe, almost 3 weeks from today for a statement of position. We believe it would be more reasonable to make that deadline a week and a half, 2 weeks max. But we believe that it should be truncated.
I'm just gonna pull up a calendar to see if I can come up with another date and then just see what the party's position is. So 2 weeks would be December 13th, which would carve off a little over a week from the current deadline. How does that sound to the company, December 13th for statements of position?
I think that is reasonable, Your Honor.
All right, and then for the rest of the parties, does anybody have any objection to December 13th being deadline for statements of position?
Thank you, Your Honor. I have a pretty full calendar and plan my calendar based on the original date. So we would prefer to keep the original deadline.
Okay, here's what I'm gonna do. We'll leave the deadline on as December 21st. However, anybody who wishes to file their statement of position earlier than that, say on December 13th, may do so. And I also just will say that I will encourage the settling parties, if you would like, to file a joint statement of position. I think that can save resources and make it very clear that what's represented is everybody's position to the settlement agreement. So December 21st will be the hard deadline. However, you can file your statement of position on the 13th or earlier if you would like. And the earlier that that's done, the better the chances are for me to be able to get a decision out quickly.
Thank you, Your Honor.
Sure, in your statements of position, Mr. Valentine, I feel like your client hedged a little bit during testimony about what provisions of the agreement AM Gas objects to and what it does not. I just would like to make sure you clearly state your client's positions in the statement of position.
Understood, Your Honor.
Thank you. And then I also want to hear from the parties and their statements of position about their position on Mr. Harrington's proposal during his testimony about provisional rates. And that is that rather than say the commission does not get a final decision issued in time for the rates in the settlement agreement to be put in place, I think by February 1st, or I think of February 1st, and it would have been a January 29th filing. If the commission is unable to get a decision done consistent with the required timing, that the provisional rate that go into effect be the rate that is proposed in the settlement agreement. So if that could be also addressed in your statements of position, then that will assist me in determining that issue. And if I am able, I will try to address that as quickly as I can.
Your Honor, on that last point, wondering if you would be okay with us filing a motion to modify the previous decision and try that route?
I would welcome it. And the only reason I didn't ask for it is I'm just trying to save everybody time and resources. But yes, I mean, that's a nice way to tee it up with a motion. I will have to wait for the response period unless it is unopposed. So make sure that you do the conferral and you confer with everybody, including AM Gas, and I get their position. If it's unopposed, then I can address that a lot quicker.
Understood. Thank you, Your Honor.
Okay, so those were just the final items I had on my list here and everything that I can think of in terms of statements of position. Anything else that we should address before we recess today's hearing? All right, I'm going to take that silence to mean we don't have anything else that we need to deal with right now. As I've already noted, we will reconvene this hearing at 2 o'clock on Friday, December 1st, and that will be a fully remote hearing. I believe it's going to be the same Zoom information that we used today. I'm getting a nod from my legal assistant, so hopefully everybody has that. I think that's everything that we've got. Thank you all for your presentations, and I will see you again on Friday at 2 o'clock. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.